Oh. Okay, good morning again. Just had to get all the Zoom stuff set up. Happy birthday, Miss Tucson.
Thank you.
23 or 24?
Exactly.
All right, excellent. Well, appreciate you working on your birthday. I hope you've got special plans over the weekend.
Just a little bit of this and that. I'm old now. I got to do stuff early.
All right, some daytime fun before you collapse from exhaustion. Well, enjoy it. Happy birthday. We have what is entitled a plea calendar this morning. Some cases were certain pleas, if I can use that phrase. Some were possible pleas. So let's figure out what we're doing. The first was Lefty Hodge, Mr. Hodge, who has always come to court. I don't see Mr. Hodge, which is surprising. And I also don't see Mr. Hodge's lawyer, but we'll do some outreach on that front. Then we have Mr. Job. Mr. Partridge, you are on the call.
Yes, Your Honor. Good morning.
Good morning. Is your client with you? Were you thinking that he was coming to court?
Judge, he sent me a message at about 6 this morning stating that he lost his phone and was asking me to resend the link to him. Judge, I have not heard from him since. I've tried to call and text over these last few hours, and even while on Zoom, while the court was doing the swearing in, and I've not heard back from him at this point. It was his intent to be here. We spoke about at about 9 o'clock last night, confirming that he had to be present. But I believe it might be the issue with the loss of the phone, Judge, that has prevented him from being at least on the Zoom platform, as I did send him the link before.
Okay. Was when you're saying it was his intent to be here, to be in your office or to be in court, or you and he had discussed a virtual appearance on his part?
Judge, we discussed a virtual appearance.
Okay. Well, if you keep trying to reach him, had you worked something out with the state, or what were we going to do today?
Judge, we were hoping to hear back from the state regarding myself and Ms. Convery's conversation last year as it relates to possible dismissal or reduction of charges. We've not had any follow-up or feedback as it relates to that per our last visit to the court. So we were hoping to get some clarity on that today.
Okay. Who's here for the gang unit?
Your Honor, Reeves Hiles for the state.
Hey, Mr. Hiles, nice to meet you.
Nice to meet you as well.
I heard you were going to be our gang person here in 8D from the state. Is that still the case?
That's correct, Your Honor.
Excellent. So I've also heard Ms. Convery won't be with the DA's office soon. Is she lingering a few more days, or she's already gone?
No, she'll be here through the 16th.
Through the 16th. So 13 more days. Tell me where you are in terms of being up to speed with the case we're talking about, by which I don't mean solely Mr. Partridge's client, but there are also some Jacksons in the mix as well. And I think Mr. Parrish had been doing some work on it, but it may be that Ms. Convery kept it. I don't recall. What I do recall is that there were some helpful and I think productive discussions about resolving some of the defendant's cases. And I want to know how you're transitioning into this.
So I was ready for a plea on Mr. Quentin Jackson today.
Okay.
From my understanding, the last holdup was making sure that the state's offer would run concurrent with his sentence in Carroll County.
Okay.
And
I think do we have Mr. Jackson today? We've got Mr. Jackson, so we'll need to get Mr. Jones. I don't see him yet, but we'll do some outreach there.
He just sent me a text and said that he's in traffic, but he's on his way.
He's on his way. Fantastic. So we'll have everyone we need. So your thought, Mr. Hiles, is that Quentin Jackson will be resolving, I think he's got 3 cases on the calendar.
Yes, that's what I was planning on.
Okay. Now there is a Tiana Jackson who's on the calendar as well. Now her lawyer sent us word earlier this week that he is medically unavailable, as in he can't be here in person. He's quarantining. I don't know. It's not looking like he's going to join us virtually. I'll have Ms. Nelson reach out to see if he's reached a point where he feels well enough to appear virtually. Had you had any conversations with?
My understanding was that there had been an offer of 5 years probation extended. And I haven't spoken with them to see if this client has accepted.
Okay. Ms. Jackson, are you here?
Yes.
Yes. Okay. So Ms. Jackson is here. What we'll do is figure out if Mr. Granham's is able to join us. If he's not, we can't do anything anyway. But what I'll do is maybe get an email chain going with you and Mr. Granham's and my office saying this is the offer as I understand it. Is this something, Mr. Granham's, that you and your client are interested in pursuing? Ms. Jackson, have you had a chance to meet Mr. Granham's yet? I know if I'm remembering correctly, when we were here before, I was trying to get you some contact information about who'd be representing you.
Yeah, I reached out, but they kept saying he wasn't in the office and that he would get back to me, but I still haven't heard from him.
Okay, I know how to reach him, so I'll do that and make sure he's plugging in here. He does have this COVID situation he's working through, so the fact that he's not here today is not making me nervous for you, but I do want him to connect with you because it doesn't make sense to have any conversation about your case, you and me, until you and Mr. Granham's have talked, so he can give you his advice. You can lay on him what you want to lay on him about this case that has been around for 4 years now. What we'll do, if you don't mind, is see if he's going to be joining us virtually. If the answer is no, you're free to go. You're also welcome to stay while we work through Quentin Jackson's matters, since you're connected, because we're certainly going to do that. But that leaves co-defendant. Is it pronounced Job, Mr. Partridge?
Yes, Your Honor.
Okay, that leaves Mr. Job, who may be working through some connectivity issues himself. We'll see what we can do. All right, and so what was your thought about Mr. Job? That's the third. There are more defendants in these many cases, but that's the third one on this calendar.
Right. My understanding was that he had declined the offer of 5 years probation, and that Ms. Convery and Mr. Partridge were still in conversation. I think Ms. Convery was just kind of a bridge until I got back to the gang unit. First day was Monday.
Okay.
And so I'm going to reach out to Mr. Partridge this afternoon.
Will you be going forward the point person on the case? Okay, so Ms. Convery will have committed your office to certain things. You will abide by those. You may improve them. You're not going to make them worse for Mr. Job unless there's an offer that was rejected, in which case the slate is cleared and you're going to do whatever you think is most appropriate.
Right.
Okay. Mr. Partridge, it sounds like Mr. Hiles is going to want a chance to speak with you about your client's situation and where it might go. Is the 5 years probation, which would clearly, looking at these charges, involve a reduction of charges, is that an offer you are recalling Ms. Convery having made?
No, Your Honor. Unfortunately, that we never got an official offer. It was my last conversation, part of the emails that I'm looking at in regard to this case, that she was still, Mr. Job was serving a federal sentence, and she was still looking to determine if the trafficking charge would be fully dismissed because she felt that he had nothing to do with it. So any drug related thing, which would, I guess, in turn change or alter the gun charge, it would be a misdemeanor possession potentially as it relates to that. So that's more along the lines of what we were thinking of.
Okay.
I can
And I'm not going to make you all negotiate it right now. I want to give Mr. Hiles a chance to speak with you, not in this public setting.
Indeed.
What is did you want to add something?
I just want to add, we're gonna dismiss the trafficking charge as to all defendants, that trafficking in heroin. So I think we should be able to come to a resolution, and I can certainly call you when we're done with court.
Okay. Mr. Partridge, how soon? I am anxious to get closure on this case as best we can, given its age. How soon should we get Mr. Job back on a calendar for him to connect with us and see if it has worked out, or if we need to do a trial on a misdemeanor?
Judge, I believe if we're able to speak with the state today, we should be able to come up with a resolution. So maybe the next week or two, Judge, we should be able to come back before the court and have this resolved.
Any reason why Mr. Hiles wouldn't be able, assuming he's freed up after court this morning, any reason you wouldn't be available to speak with him?
Judge, I have a 2 p.m. preliminary hearing in Coweta County. Outside of that, Judge, I'll be free.
Great. Okay. So I'm going to trust you guys connect today. And what we'll do is reset this out a few weeks. I can't promise it would be only 2 weeks from now, just because Ms. Nelson is good at getting calendars out far in advance. But we could always do an addendum if everyone is agreeing, hey, that's a good day, and isn't going to insist on, hey, I need 30 days notice or something like that. Mr. Hiles, if you would take the lead in letting Ms. Nelson know, I spoke with Mr. Partridge. I think we've worked this out. Could you get it on a calendar soon? Because Mr. Job is on bond, it's pretty easy to get everyone connected. We don't have to worry about adding to a jail transport. We could do it on any day that works for your schedule and Mr. Partridge's.
Great, I'm flexible, so we'll work it out.
Okay. So Mr. Partridge, hopefully you will be able to reconnect with Mr. Job, especially if we're going to handle a plea or whatever the disposition is on a unpublished calendar. I mean, we'll publish the addendum, but if it had to get mailed to Mr. Job, that might push it out further than what you've got in mind. And so we'd be relying on you getting word to Mr. Job that he either needs to come to court, if that's your preference, or that he needs to plug in via Zoom.
Understood, Your Honor. He's been very responsive, and we've spoken consistently throughout the last few weeks since we last appeared before the court. So I don't think that'll be an issue, Your Honor, but I'll definitely take lead on that and have responsibility there.
Fantastic. All right. Thank you. So you're free to go. If you do connect with Mr. Job, let him know that you and the prosecutor, the new prosecutor, are going to talk about the case. If for some reason Mr. Job comes here, I'll let him know the same.
Thank you, Your Honor. Y'all have a great day and a good weekend.
You too.
Thanks.
All right. Did you hear anything from Mr. Granums?
No, not yet.
Okay. Mr. Jones?
Good morning, Your Honor.
How are you?
I'm well. How are you?
I'm well. Thanks for getting in here. The Jacksons let us know you were stuck in traffic.
My apologies on that.
Not a problem. We were, as you can see, we were busy working with a co-defendant. So Mr. Hiles, I don't know if you two have met before in person. He's right there with red tie, dark suit. The only Mr. at the state's table. He announced that he thought that your client, Quentin Jackson, was likely in a position to resolve his 3 cases today. Mr. Jackson is here. We got him from Carroll County. Do you need time to talk with him?
Just a moment. Just a brief moment.
Okay. That's the only case left on this morning's calendar. So why don't you, if deputies can get you back with him, spend a little time with Mr. Jackson. Do you need to talk with Mr. Hiles for
Like 2 minutes before he goes to speak.
Great. You guys talk. Yes, ma'am. Hey, how are you? Oh, you were going to walk someone in.
Yes, and here.
All right. Who is here?
Cortez Gibson is on the court's calendar for Tuesday.
Do you have his case number?
It is 22 SC 182238. I forgot I had on the mask. It's become, it's kind of become a thing that you're doing now.
It is. I'm glad for most folks it's a thing. I had a relative fly here yesterday, and she was one of like 3 people on the flight with a mask.
Yeah.
And that's just a breeding ground.
Yeah,
So,
it is very interesting now, just
Yep.
depending on where you're traveling.
eight,
Take one.
2, 8, 8. Mr. Gibson, why don't you come up here, please, with Ms. Griggs?
Need the number? Need the number?
Oops, that's not it. Okay, good morning.
Good morning.
So we did have a calendar a few days ago, and you weren't here, and more importantly, Mr. Gibson wasn't here.
Yes, Judge. And Mr. Gibson reached out to me on Tuesday, letting me know, Tuesday evening. Obviously, that was beyond the time that the calendar was actually held, letting me know that he had just received a notice indicating that he should be in court. I didn't receive a notice, but
You did not?
I did not.
Okay.
And
Hey, can you guys go in the jury room? You can talk all you want, but no problem. You did not receive a notice.
I did not receive a notice.
Okay.
So I'm not sure of, what that is. It's really not an excuse for it, Judge. But I wanted to, once we realized, he reached out to me, he inquired as to whether or not he should appear the next day. And I reached out to the court. And this was the first opportunity we had to be present. I believe that he received his notice late because there was an address issue. His address needed to be updated.
We'll talk about that.
Yes,
So the clerk sent something to you at a Flat Shoals Parkway, Suite 332 address.
Yes, I'm actually in John Wesley Dobbs. So it could be that with the pandemic, with the notice, it's with the entry or whenever I filed it, maybe they sent it to a prior address that I have, because I've represented a number of people.
And you're not at the Flat Shoals address
I'm
anymore.
not that address.
Okay, so you'll need to figure out with the clerk's office, I guess, how to get that updated, because that suite's going to have a big stack of notices for
Yes,
you.
well, unfortunately, the Fulton County Clerk's Office sends things where they want to.
They do. Well, what they do actually, they send them where it reaches into the system and has an address for you. You just need to get whatever address is associated with Maya Griggs, no longer Flat Shoals, because
Right.
it's automated. It's not like there's a little gremlin saying like, I'm gonna pick a random address for Ms. Griggs.
Sure.
At some point, I trust you were at this Flat Shoals Parkway.
Yes.
Okay, but you're not anymore.
Not anymore.
So that needs to get revised. There was a notice sent to Mr. Gibson at 87 Pine Street in Fairburn.
Yeah, that's my old address.
That's your what?
That's my old address.
Old address. Okay. Well, there's one more sent out. They send them out everywhere. I wonder where this one went. The bonding company. Okay, so you're not at Pine Street anymore.
No.
Okay, we should have an address change form here. We'll do that today.
Yes, Judge.
That'll be part of the process.
Yes, Judge.
In the system, even though that's where the notice was sent, it lists Mr. Gibson as, it has both. It's got also a Meadow Glen Circle.
Yeah, that was the second address. It came too late.
Okay, what's the right address?
That's the address I'm at now.
Okay, so we'll want to make sure it's got a little pin next to the Pine Street one. So I think that's where the clerk sends things. We need to correct Miss Griggs's pin also, because
Yes.
she's not in Decatur anymore. Okay. So that's why Mr. Gibson wasn't here. What you're saying, Mr. Gibson, is basically the day of court, the mail got forwarded to Meadow Glen. You saw it. Oh, it's today. You did the right thing, which is call your lawyer, who I know because I saw her name come up on the phone system. She reached out, and you guys came in. So as long as we get both the addresses corrected, but most of all yours, Mr. Gibson, because ultimately it's your job to be here. Your lawyer will help remind you if she knows you've got court, but you're the one who needs to get yourself to court so that we're able to move things forward. Let me look at one last thing. Your bond, you had to stay away from the alleged victims. It says you have to reside at 87 Pine Street. So why do you not live there? I'm all right that you've moved, but why do you not live where the judge told you had to stay?
Oh, that's my mom house. She moved.
Your mom moved.
Yes.
Okay. And this new address, the Glen Circle or whatever it is that your mom's address now?
Yes.
Okay. Well, you're not on pretrial supervision, so you should let the bonding company know, because if they're looking for you, they're going to be banging on the wrong address.
And Judge, I could submit a motion to the court if that would just help to change the address.
Yeah, why don't you do that? Just a motion to modify the bond. The only modification will be the new address. And then if you'll grab one of those change of address forms and just fill that out on behalf of Mr. Gibson. And then since we've got everyone here, I think it was for plea and arraignment.
It was.
So if you're going to waive arraignment,
Yes,
you
Judge.
can fill out the waiver form.
I'll do that.
And then we'll get a scheduling order entered that will give Ms. Charles a deadline to get discovery to you. And then you'll have a deadline to file any motions, evidentiary motions, if that's what flows from discovery. And if not, then we'll see everyone for a status conference a ways down the road to make sure you got everything you needed. That will be after the motions deadline. So that won't be a time to say, hey, how about a motion to suppress? It'll just be making sure that when we put this on a trial calendar, there are no surprises. It's
Yeah.
also time to plead the case out if that's what people want to do. So it's sort of like a final plea calendar, but we'll call it something different now. But that's it. Ms. Charles, do you have anything in connection with Mr. Gibson's case you want to share?
No, Your Honor, we'll talk.
Is it a particularly complicated discovery case, if you know?
No, Your Honor.
Pardon me?
No, Your Honor.
Okay.
So myself and Ms. Grigg.
I hope we work together. That'd be good.
Judge, I hope we can work it out quickly.
Okay, I'm just looking at the charges. Yeah, okay. Shouldn't be super complicated, but we'll see. Ms. Griggs, anything else on behalf of Mr. Gibson?
No, nothing on behalf of Mr. Gibson, Judge.
Okay, so change of address form, waiver of arraignment form, and you guys should be good to go.
Thank you so
All
much.
right.
It's good to see you.
Same.
Well, see you, maybe not you see me.
That's it? All right. Do you have anything on the afternoon calendar? Okay. I don't know that a whole lot will happen with that unless you and Mr. Terry have been talking, because I assume you've heard he's coming off all the cases. Yeah, which may make him less productive, but we'll see. Okay, we'll see. See you then. Wait, you guys are leaving again? Okay, because now it's time. What are you looking for?
Ms. Griggs, I need a card.
Ms. Griggs, do you have a new business card with your new address?
I do not. Sorry, it's very problematic because I keep forgetting the address, so I need to look it up.
You need to help Ms. Nelson out in some way.
It's a lot of information. No, on here it actually asks for my address. I'm gonna sit down and write it in.
Okay.
Oh. Yes, I did. Let's see.
Ms. Charles, this DeMarco Barneswell bond, it's a CP case. Does he have why is it yours? Does he also have an SC case?
No, it's it was, because of the, he was a law status.
Oh,
So we'll get that out.
but did Mr. Barneswell have an SC case?
Yes.
He must have.
Yes.
Okay, but he had this CP case and that's holding him. And so you're standing in for some prosecutor in pre-indictment to say, hey, we're agreeing to.
That's what you keep in for.
Got it. Okay, makes sense. Thank you.
I'll circle back on it.
All right, Mr. Jones, are we ready for Quentin Jackson?
Yes, Your Honor.
And what is your understanding of, it's three cases.
Yes, Your Honor. We've entered an agreement with the state. It would be for a 5-year serve.
Well, you don't need to tell me exactly how it's going to play out, but does it resolve all three cases? Okay.
In
And
addition to the kind of floating out there 17 case that the state represented that they weren't going to pursue.
there's a 2017 case.
Yeah, it was a 40-count entering car indictment that, Your Honor, we spoke about the last time the state.
Is it an unindicted case?
It was indicted and then dismissed. And then there was this idea that they were going to bring it back, but they decided not to.
So they'll put something on the record that it is forever put to rest.
Exactly,
Okay.
Your Honor. And I have that number in case the court.
Please.
It's a 17 SC 151113.
Thank you. Mr. Hiles, are any of the three cases on the calendar being null prossed, or there will actually be a plea to one or more counts in each of the three cases?
There will be pleas to one or more counts on each of them.
I'm just asking so I know what to structure. You will get on the record, hey, we're reducing this, we're dismissing that, but no case is being dismissed outright. Mr. Jackson, you believe, is going to be entering a plea to some number of counts in each of the three cases on the calendar. Okay, that's your understanding, Mr. Jones?
Yes, Your Honor.
Great. Any reason we shouldn't bring them out?
No, Your Honor.
Let's do it. I'll have one request of both of you. When you're talking, if you don't mind having your mask off, you're welcome to have your mask off the whole time. That's up to you. But Ms. Rivers, who's going to be taking all this down, will hear you a lot better sans mask. You are welcome to stay at the table. You can be at the podium. Either way works as long as you've got the microphone in front of you. Mr. Hiles, same deal. You're welcome to stay at the table. Oh, where do you want? We're going to bring them out. You want them at the table or the podium?
Table, Your Honor.
Table or podium?
Because
You pointed at the podium and said table.
I saw a table on the podium, but I'm at the podium.
Podium, please. So Mr. Hiles, if they're going to be there, you need to be at the witness stand so they can see you, but you'll have a microphone that works. You can just move it, and we should be good to go.
Your Honor, it was my plan to go over the waiver of rights in each indictment at the same time instead of doing it individually.
I'll structure this as a plea to when we get on the record in just a minute, to the three cases. And so when you're asking Mr. Jackson, does he understand certain rights and that he's waiving certain rights, that will apply to all three. And we can clear anything up we need to during the colloquy. All right, are you ready to go forward? Do you need a minute with the paperwork, or do you have what you need?
I am. Do you do the written paperwork in this courtroom?
So normally there is a plea form that sets forth all the rights that Mr. Jackson will be waiving by going forward. And I thought that's what you went back to have him fill out. But I don't want to, if we're ready to go forward, I'm comfortable going forward and just making a written record through Ms. Rivers's transcript.
We're comfortable going forward, Your Honor.
Well, why don't we do that? But we're going to talk when we're done, because I want to talk to you about some other cases, and I'll show you that form. And you don't fill it out, the defense does, but you'll know what it is, and the defense will be able to do that in the future.
Then I How have you been doing this, signing indictments? I think that,
Electronically.
Okay.
So I'll cover that.
all right.
All right. You don't need, I mean, unless you're keeping those for your own use, you don't need to do 3 in this case. You would just do 1. But if those are for future reference, you can take as many copies as you want.
Thank you, Your Honor.
Sure. Ms. Rivers, are you ready?
I'm ready.
You ready?
Ready, Your Honor.
Ms. Rivers, are you ready?
Yes, Judge, I'm ready.
Great. Good morning.
Good morning.
Good morning, Mr. Jackson.
Good morning.
How are you, sir?
I'm good. How about yourself, sir?
I'm all right. I'm gonna make sure you speak loudly into that microphone. So slide over a little bit more. Ms. Rivers needs to be able to hear you. And I know Mr. Jones will project. Mr. Jackson, your lawyer, Mr. Jones, has told me that you are prepared to enter pleas in the 3 cases that you and I have. They're old cases and we've talked about them some at different times. But what Mr. Jones has told me is that after negotiating on your behalf with the state, you are, after he has negotiated on your behalf, you are prepared to go forward. Is that correct?
Yes, sir.
Okay. In just a moment, Mr. Hiles, who's the prosecutor, the new prosecutor on the case, is going to put you under oath. Once you're under oath, you're going to be asked a bunch of questions. Most of them will come from Mr. Hiles. Some will come from me. You need to answer those questions truthfully and completely. Will you do that?
Yes, sir.
Great. You're welcome to have your mask down when you're talking too. That'll make it easier for folks to hear you. The other thing I need you to do is to let your lawyer know if at any time you have any questions or something is not making sense to you or you're confused by anything. He's done a good job of letting you know what to expect, but sometimes someone says something that's different. And I'm making this up, but it may be he negotiated a 5-year sentence for you. And Mr. Hiles misspeaks and says, and the state's offer is 10. If you were expecting 5 and you hear 10, you need to be gently elbowing Mr. Jones. They're like, wait a minute, what's going on here? And he'll let you know what's going on, or I'll let you know. I'm happy to answer the questions as well. But we won't know you have questions unless you're saying, I don't get what's going on. Will you do that?
Yes, sir.
Excellent. We're good to go. Mr. House?
Okay. And Your Honor, before we get started, just so you know, this is the recommended sentence for all 3 indictments is 5 years to serve 3 years, balance on probation. And it is to run concurrent with his cases in the Coweta, Carroll, and what was the troop? In the troop circuit.
Will you have at some point indictment numbers from one of you will have indictment numbers, because we'll want to literally put those numbers on the final dispositions. I think if we say those words, it'll be enough, but it is much more guaranteed that what you're recommending occurs if I'm able to put on there indictment 1, 2, 3, 4 from Coweta, 5, 6, 7, 8 from Carroll.
Yes, Your Honor.
You've got all that. Excellent.
I will get that.
Okay.
We don't have that just yet, but we'll get it for the.
Okay. I won't sign the final disposition until we get it. But that won't change anything. It'll be, if I go along with what's negotiated, it sounds like it'll be 5 years to serve 3. I assume it'll be credit for the time that Mr. Quentin Jackson has served, and then 2 years probation.
Correct.
Okay.
And as to indictment 18 SC 162228, the state is going to null pros count 1 participation in criminal street gang activity. The state will also null pros count 8 trafficking in heroin. So that means as to that indictment, Mr. Jackson will be pleading to counts 2 through 6, as well as count 9 through 13. And then the state's also going to null pros the 2 misdemeanors, count 15 and 16.
Got it.
And he will be pleading to the indictment on 18 SC 163993, as well as pleading to the indictment in 19 SC 168784.
Understood.
All right. Mr. Jackson, will you please raise your right hand best you can? Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. You can put your hands down. Will you please state your true, correct, and legal name?
Quentin LaTroy Jackson Jr.
Okay.
Mr. Jackson, are you at this time taking or under the influence of any alcohol, drugs, or medicines?
No, sir.
Are there any medications that you normally take that you have not been given today?
No, sir.
Mr. Jackson, how old are you and how far have you gone in school?
25 years of age, some college.
Are you able to read, write, and understand the English language?
Yes, sir.
All right. Do you understand that you were charged in indictment number 18SC 162228 that you were charged with 6 counts of participation in criminal street gang activity, 1 count of trafficking in heroin, as well as 5 counts of possession of a firearm during the commission of a felony, 1 count of possession and use of or 2 counts of possession and use of drug-related objects. Do you understand?
Yes, sir.
You understand the state will be null processing the count 1 participation in street gang activity, count 8 trafficking in heroin, and count 15 and 16 possession and use of drug-related objects. Do you understand?
Yes, sir.
Do you understand that in indictment number 18SC 163993, you were charged with 2 counts of theft by receiving stolen property, as well as 2 counts of willful obstruction of law enforcement officers? Do you understand?
Yes, sir.
Okay. Do you understand that in indictment number 19SC 168784, you were charged with 1 count of fleeing and attempting to elude, felony, 1 count of willful obstruction of a law enforcement officer, and 1 count of obstruction of windshield violation? Do you understand that?
Yes, sir.
Okay. Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, sir.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in each of these indictments, including any potential defenses?
Yes, sir.
Do you need more time to speak with your attorney as it relates to these offenses?
No, sir.
Are you satisfied with your attorney's services?
Yes, sir.
Mr. Jones, do you waive formal reading of this indictment?
So waived.
Do you waive formal reading of all 3 indictments?
So waived.
And Mr. Jones, do you waive any and all defects in all 3 of these indictments, including any with respect to your client's name?
So waived.
Okay. Mr. Jackson, has your attorney advised you of the minimum and maximum sentence for each charge that you are pleading guilty to?
Yes, sir.
Okay, I'm gonna go over the sentence ranges on each of these charges that you are pleading guilty to, and just to make sure that you understand your exposure range. In indictment 18SC 162228, do you understand that you are pleading to counts 2 through 6 participation in criminal street gang activity, and that each of those counts individually carries with it a potential sentence range of 5 to 20 years?
Yes, sir.
And do you understand that you are pleading guilty to count 9, possession of marijuana with intent to distribute, which carries with it a potential sentence range of 1 to 10 years? Do you understand?
Yes, sir.
And do you understand that you are pleading guilty in counts 10 through 14 to possession of firearm during the commission of a felony? These carry with it a potential sentence range of 5 years to run consecutively to the counts that you are to the underlying counts. However, the state will be recommending that those sentences be suspended, which means you will not be serving active probation or incarceration on those sentences. Do you understand?
Yes, sir.
Okay. Moving to indictment number 18SC 163993. Do you understand that counts 1 and 2 carry with it a potential sentence range of 1 to 10 years?
Yes, sir.
And do you understand that the 2 counts of willful obstruction of law enforcement officers carry with it potential sentence range of up to 12 months incarceration and up to a $1,000 fine. Do you understand that?
Yes, sir.
All right. Moving to indictment number 19SC 168784. Do you understand that the felony count of fleeing and attempting to elude carries with it a potential sentence range of 1 to 5 years?
Yes, sir.
And do you understand that count 3, willful obstruction of law enforcement officers, carries with it a potential sentence range of up to 12 months incarceration? Do you understand?
Yes, sir.
And do you understand that the window or windshield violation carries with it a potential sentence range of up to 6 months incarceration and up to a $1,000 fine?
Yes, sir.
Okay. Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 5 years to serve 3 years with the balance on probation?
So I'm going to interrupt you there for a second so that we refine that a little bit. I think the sentence is going to have to be 10 years because it would be 5 years to serve 3 on some of the counts with 2 years probated. But there are those few gun charges you heard Mr. Hiles talk about where it has to be consecutive. But I assume the recommendation is suspended. And so what the sentence really would be structured as, I see another option, which would be 8 to do 3, but then there's no probation in there, and I'm going to want probation. But I think it is technically going to be 10 years, the first 3 of which are in custody, credit for time served, parole eligible, followed by 2 years on probation. That's your 5 to do 3, followed by 5 years suspended. I think that's the only legal sentence that I can impose. I mean, I could do just 3 years to serve, followed by 5 suspended, but I'm not comfortable with a non-probated sentence. So I don't want Mr. Jackson thinking 5 serve 3, that's my sentence, because there is this 5 years of suspended time legally must follow whatever the highest number is. And I'm assuming the sentences, just sticking with the indictment ending in 228, the way I'd structure it for the gang activity counts, those would all be 5 to serve 3, balanced probated, and they'd run concurrently with each other. So I want to be clear, the net effect of this is a sentence of 3 years in custody, credit for time served, followed by 2 years probation, but there has to be the 5 years suspended. I can't run the gun counts concurrently. So if that upsets the apple cart, folks need to talk a little bit, but I don't want to bring that up only at the very end saying like, well, technically it cannot be 5 serve 3. That's not a legal sentence. It'll get sent back to us. I don't want to be dragging Mr. Jackson back in here. He's got all these other cases elsewhere.
Can Your Honor just describe that one more time? I just want to make sure I'm clear for my client.
The core of the sentence is exactly what was negotiated. And on all of the felony counts, other than the gun charges, on all the different cases, I intend to impose a sentence of 5 years to serve 3 with the balance probated. That's what's been negotiated. There are 4 counts in the 228 indictment that are the firearm counts, meaning possession of a firearm during commission of a felony. They can run concurrently with each other, and that's exactly how I'll do it. They have to run consecutive to the longest other count in that indictment, which would be the 5 serve 3. I can suspend them, and I'll do that. But there is a 5-year suspended sentence that has to start after Mr. Jackson finishes his probation.
Probation, is that running consecutive as well?
No, the probation, the simplest way I can think about it is forget about all the other cases because they're going to fold into the one with the most counts. Mr. Jackson has it looks like 6 felony counts. 5 of them are gang counts. 1 is the marijuana. The sentence on all of those is going to be 5 serve 3. 3 years to serve, 2 years probation, total of 5. He may get paroled, and so there'll be a little parole baked in there, but the clock is 5 years long, and it's been running. How long you been in?
This month would be 36 months.
Okay, well, you've almost done your 3 years. So forget about parole. They'll get you to 36 and you'll be out. So you're gonna have 2 years probation, I don't know what's going on in these other, when I say you get out, I don't know what's going on in Coweta and Carroll and Troop. You may have more time there. I don't have any control over those jurisdictions. But for these 3 Fulton cases, 5 served 3, balanced probated. So your probation is going to start real soon. If you're almost on 36 months, just a crazy amount of time to be stuck in the county jail. After that probation is over, you're done, you're not being supervised, but you have a 5-year suspended sentence for these gun counts. I can't make that go away. There's no supervision. There's no probation officer. There's no fee that you're paying for supervision.
Yes, sir.
You understand that?
Yes, sir.
Okay, so I figured you did, but I wanted Mr. Jones to be able to explain that. So it's technically going to be a 10 to serve 3 sentence. Serve 3, almost done. 2 probated, 5 suspended. We're all aligned on that, Mr. Hiles,
Yes.
Mr. Jones,
Yes, Your Honor.
most importantly, Mr. Jackson.
Yes, sir.
All right, I'll get out of the way. Back to you.
I do want to point out, so I was wrong. I believe I said you'd be pleading to counts 10 through 14, possession of firearm during commission of felony. It's count 10 through 13 because you're not charged in count 14.
Correct. It's 4 counts of firearms.
Correct. And then also, Your Honor, for sentencing purposes, count 11, 12, and 13 would merge with count 10 because it's all the same underlying felony.
Yep.
Okay. Okay. So all that being said, do you understand that the court, that is the recommendation that the state's making, but the court does not have to accept that, and the court can sentence you up to the maximum on each charge and run those consecutive one after another. Do you understand?
Yes, sir.
Okay. Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts? Do you understand?
Yes, sir.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, sir.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to the revocation of the balance of your sentence? Do you understand that?
Yes, sir.
And do you understand that you are not allowed to possess, use, or use a firearm while on probation? Do you understand that?
Yes, sir.
And in your case, you will be a convicted felon, so you will not be allowed to possess, use, or transport a firearm unless and until you have your rights restored. Do you understand that?
Yes, sir.
Mr. Jackson, are you a United States citizen?
Yes, sir.
Do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Pardons and Paroles, and that no one can guarantee parole no matter what anyone has told you? Do you understand that?
Yes, sir.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand?
Yes, sir.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, sir.
And do you understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, sir.
You understand that by pleading guilty, you're giving up the following rights. Do you understand that you are giving up the right to trial by jury?
Yes, sir.
Do you understand that you are giving up the right to remain silent and not incriminate yourself?
Yes, sir.
Do you understand that you are giving up the right to confront witnesses against you?
Yes, sir.
Do you understand that you are giving up the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case?
Yes, sir.
Do you understand that you are giving up the right to presumption of innocence?
Yes, sir.
You understand that you're giving up the right to testify on your own behalf and to present other evidence?
Yes, sir.
Do you understand that you are giving up the right to subpoena witnesses and compel the production of evidence?
Yes, sir.
Do you understand that you are giving up the right to have the charges against you proved beyond a reasonable doubt?
Yes, sir.
Do you understand that you're giving up the right to appeal if convicted of these charges after a trial?
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
How do you plead to the charges and indictments in indictment number 18SC162228.
So you've got the option of pleading guilty or not guilty.
Guilty.
And how do you plead to indictment number 18SC163993?
Guilty.
And lastly, how do you plead to indictment number 19SC168784?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, sir.
And do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that you have 4 years from today's date for the felony charges and 12 months from today's date for the misdemeanor charges to file a habeas corpus plea challenging the voluntariness of this guilty plea?
Yes, sir.
Do you understand that you have until the end of this term of court to file a motion to withdraw this guilty plea?
Yes, sir.
Okay, and Your Honor, just before I go into the factual basis for each of these charges, I just want to put on the record that the state does agree that as part of negotiations for entering the guilty plea into these 3 indictments, the state is not going to bring back any of the charges against Mr. Jackson in indictment number 17SC151113.
151. This is the one that Mr. Jones brought up at the outset.
That's correct, Your Honor.
Okay, and that's a case that the state had dismissed.
I'm not sure if it has been null prossed or placed on the dead docket.
So Judge Ellerby has the case. There is a defendant named Austin Hammett, where it looks like it's still open for Mr. Jackson, who is the man of the hour. Let's see what it says. Null pros. So in November of 2018, the state, Ms. Hall, wonder why this case is with Judge Ellerby. Anyway, Ms. Hall, apparently they were going to re-indict. That's what it says. Null pros to re-indict. Hence your concern.
Exactly.
Okay. But this is not a matter that the state will be seeking to pursue in any way, shape, or form in Fulton County Superior Court against Mr. Jackson.
That's correct. That's part of our negotiations.
Got it. That's on the record.
Thank you, Judge.
Okay. All right, Your Honor, I'm going to go through the factual basis for each case individually. I'm going to start with the largest case. That was going to be indictment number 18SC162228. Your Honor, were this to go to trial, the facts would show that on May 12th of 2018, officers with the Atlanta Police Department responded to 3183 Abbey Drive, Atlanta, Georgia, in reference to a stolen automobile. Officers spoke with the victim, Mr. Robert Smith, who advised that his rental car had been stolen from his home. The vehicle was a 2017 Infiniti Q50 with Georgia tag CEX 5384. On May 15th, 2018, Officer B. Miller of the Atlanta Police Department located the Infiniti Q50 behind an abandoned house at 4086 Fairburn Ave, Southwest, Atlanta, Georgia, Fulton County. APD was able to lift 7 fingerprints from the recovered Infiniti Q50. Atlanta police then ran the fingerprints from the stolen Infiniti Q50 through their database and received hits on 3 individuals. The fingerprints came from the interior sunroof. The interior sunroof fingerprints matched Ricky Wolf. A temporary tag that had been taken off and placed, exchanged for the tag of the vehicle, had the fingerprints of the defendant, Mr. Quintavious Jackson. And finally, on the exterior of the passenger side window, there's fingerprints of the Quintavious Walker. And I apologize. This Quintavious Jackson is separate. I believe it's a sibling of Mr. Quentin Jackson.
Ricky Wolf, I know well, through other cases I have with him. He's not named as a defendant in this case.
No, he's not.
Okay.
No, he's not. But they are.
You don't need to add him. He's got other stuff going on.
I'm very
just
aware
curious.
of everything he has. And
Okay.
we have more coming to you.
If I may, what case number are you referring to?
This is APD 181580660.
Or the
But what's indictment does this
Oh,
cover?
this is the gang indictment 18SC162228. The reason I'm reading this is because they are all gang members. They're in the same gang and it's interrelated. I haven't gotten to the charges that involve.
So this is at some point going to connect to.
This is going to
Quentin
connect
Jackson.
to Mr. Jackson. This is what led to the search of the house.
Okay.
APD then took out arrest warrants for Mr. Wolf and Mr. Quintavious Jackson for the theft of the Infiniti Q50. On June 7th, 2018, APD Fugitive Unit, as well as the U.S. Marshals, executed an arrest warrant at 4048 Fairburn Ave, Southwest, City of Atlanta, Fulton County, in an attempt to arrest Quintavious. This location is just 1/10 of a mile away from where the vehicle was abandoned, 7 houses away. At the residence of 4048 Fairburn Ave, the officers located Mr. Quintavious Jackson, as well as his siblings, Quentin Jackson and Tiana Jackson. This location was also known as a hangout for Wolf, as well as other members of the criminal street gang Boys in Black, and sometimes referred to as 27 Unos.
27 what?
Unos.
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 Okay.
As officers knocked and announced, the surrounding officers observed Mr. Quentin Jackson attempt to flee from an upstairs bedroom window. After he saw the officers had surrounded the residence, he then ran back into the home, and they found him inside the home, along with Tyrell Chambers, Vincent Way, who is now deceased, Quintavious Jackson, and Tiana Jackson. Officers also found Mr. Ibrahima Job, who was the boyfriend of Tiana, inside. During a protective sweep of the house, officers observed drugs from what they believe to be marijuana, scales for residue on them in plain view, which preempted Investigator D. Whitlow to apply and receive an additional search warrant for the house. During the search warrant, officers recovered a number of guns, ammunition, scales, and drugs. The following is what was recovered during that search warrant. Downstairs in room 1, officers recovered a backpack containing personal effects of Mr. Tyrell Chambers. They also recovered a digital scale, 2 vehicle key remotes to unidentified vehicles, a high point handgun, an FN assault pistol.
You don't need to, unless, are those the guns that are the basis of the 4 counts?
They are.
Okay.
That's why I'm putting them on there. The AR-15 tactical assault rifle and a Mossberg shotgun. Also recovered was a 50-round drum for the pistol and 3 pistol magazines. In the kitchen, officers recovered a vacuum sealer with bags that matched a bag of vacuum sealed marijuana that contained a particular approximately 60 grams of marijuana. Officers also recovered 2 handmade gang posters for Boys in Black /27 Unos. Upstairs, officers also recovered a Glock 19 9mm, as well as 60 grams of heroin, which is going to be null prost.
And why are you walking away from the heroin?
I think where the heroin was recovered would have been it was hidden very well, and I think it would have been tough to put that on anybody because of where it was hidden.
Okay.
Most of the other stuff was rather in the open, and so that's the reason for walking away from that. That would have been the basis of the state's case, and that is what the state would have put up were this case to go to trial. Let's see. All right, Your Honor, I'm going to move on to indictment number 18SC 163993. Your Honor, were this case to go to trial, the facts would show that investigator Nikita Moss of the City of South Fulton Police Department responded to a potential stolen vehicle, which was located at the intersection of Cascade Road and Fairburn Road in City of South Fulton, Fulton County. Upon arrival, a black male seen attempting to get into the car was told to stop, at which time he was fled, and a description of the individual was put out to authorities in the area. Officer Moss, or Investigator Moss, then did observed the VIN number on the vehicle. Based on her training and experience, believed it to be a fake VIN, which could be seen peeling off. Afterwards, there was a VIN number. The actual VIN number was seen directly underneath the temporary or the replacement VIN, and it came back as the stolen 2016 Dodge Charger belonging to an individual named Blake, or named Eric Pollard. Shortly later, Officer Slay of the City of South Fulton Police Department came out with his canine to do a sweep of the area, and he observed the same male that he believed to have fled from the Dodge Charger, getting into the backseat of a black sedan. Deputy Slay then put out a all points bulletin to be on the lookout for that particular black sedan. But also on his sweep, he discovered a backpack that had the driver's license of Mr. Quentin LaTroy Jackson Jr., along with a stolen firearm that belonged to Mr. Blake Atwater, which had been stolen from the accused house. He was also, I guess, Officer Slay also gave commands for the individual getting into the black sedan to stop. Afterwards, after recovering the license of Mr. Jackson, a photographic lineup was presented to the officers who observed Mr. Jackson, and Officer Alexander was on scene, positively identified Jackson as the person she saw, the driver of the 2016 Dodge Charger that she saw flee, and Detective Terrence Jackson positively identified the defendant Quentin Jackson as the person who got into the back of the black Nissan sedan that was fleeing the scene. That would be the basis of the state's case as to that indictment. Moving to indictment number 19SC 168784. The facts would show that on May 31st of 2018, Officer Mayfield of the Fulton County Police Department observed a black Ford Taurus that had a windshield cracked across the center of the windshield at the intersection of Butner Road and Campbellton Road, City of Atlanta, Fulton County. Officer Mayfield followed the vehicle to Fairburn Road and Campbellton Road. The vehicle made a right onto Fairburn Road going southbound, at which time Officer Mayfield activated his emergency equipment in the vehicle, immediately swerved into the northbound lane of traffic, placing at risk the individuals driving in that direction as it fled from a lawful blue lights of an officer requesting him to stop. The driver, which was found to be Mr. Quentin Jackson, abandoned the vehicle at 3877 Stone Road, was given another command to stop, at which time he fled on foot, and a short chase ensued, and he was apprehended and taken into custody at that time. Co-defendant Mr. Tyrell Chambers was also taken into custody as the passenger in the van. Your Honor, that would be the basis of the state's case for that particular indictment.
All right. That's it?
That's it.
Okay, very thorough. Appreciate it. Ms. Tucson, the birthday girl, tell me, please, if Mr. Jackson is on probation anywhere, or if he's got any convictions in your system.
Okay, from what I see on here, he is serving time at the moment for a case in Coweta. It is 2018R012.
What are those charges?
Entering a vehicle, theft by taking, and the adjusted time to end is August 8th, 2039.
For the prison part to end or the overall sentence?
I mean, the overall sentence, that's when it ends.
Okay. Are you able to tell if Mr. Jackson will be on probation for that many years, or what does your system show?
Give me 1 second. I'll look that portion up of it.
Thank you. Yes, that's the same. That's the same. Thanks. Yes.
Okay, I'm reading the sentencing sheet, and there's more than one count of the entering an automobile and a theft by taking, but they're all run concurrent. 5 years on most of those. One of the theft by taking is 10 years. So the total sentence is 20 years to serve 5, remainder on probation.
Got it. Okay. And right now, what your system shows is that Mr. Jackson is serving the custodial part. He's on the 5.
Correct.
But whenever that is paroled, there are 15 more years of probation remaining.
That is correct.
Okay. And that's all that's showing up in your system?
Yes, that's the only one that's, indicted, and he is on for the probation.
Okay. Any closed cases showing up, or that's your one conviction?
It's just the one on here.
Okay. All right. Thank you.
Your Honor, forgive me for interrupting. I believe that one was supposed to run concurrent with Troop and Carroll County as well. But for whatever reason, Carroll closed the case. And so there's a bit of a confusion with regard to his sentencing, but that one sentence should be for all three. And we'll just have to get that to the court.
Okay. So you're saying Carol may have said, gosh, given the length of that sentence in Coweta, we'll just close ours out?
Yeah, they may have, but you
Okay.
know, we just want to make sure that, you know, we're all on the same page.
Yep.
He's not serving, you know, extra time.
Okay.
I can reach out. I got some close friends over there. I can
Okay.
reach out.
I'll let you all figure that out. Good morning, pretrial.
Morning.
How are you?
Good, how are you?
I'm all right. What do you have for Mr. Jackson in terms of cycles and convictions, et cetera? Please.
I show the same convictions as Miss Tucson. I'm showing 19 total cycles, 17 out of Georgia and 2 out of Alabama. The 2 out of Alabama cases were both from 2017. Unlawful breaking and entering a vehicle. There's no disposition listed. And then the second case is 8 counts, 3 receiving stolen property, and the rest are drug offenses, also no disposition listed. And I'm also showing 2 outstanding warrants, 1 out of College Park for aggravated assault from 2019, and then 1 for a FTA in Angiston, Alabama, and that warrant date is from January of 2021.
Okay. Thank you for sharing that. Mr. Jones, what do you want to tell me about Mr. Jackson?
Well, Mr. Jackson obviously has been through the system a couple of times, but he's been a model citizen since he's been in custody.
Yeah, there are a bunch of different dates that have popped up here. October 18th was the latest of the 3. You know, there was a search warrant at the house on Fairburn Avenue. Mr. Jackson may have been arrested then. He clearly got out because May 31st, so a few weeks later, he's driving this Taurus, taken into custody, must have gotten out because then we've got the case in October of 2018. When did Mr. Jackson finally go into custody such that he's able to say, gosh, I've been in for almost 3 years?
June 29, 2019.
June 29, 2019.
And was that in one of these other counties?
Fulton.
For what?
Which is failure to appeal.
FTA, failure to appeal.
Oh, okay. Those will catch up. All right. Got it.
Well, Your Honor, like I said, we just respectfully request that the court accept the recommendation and the negotiation between the state and the defense. We believe that it's appropriate. Mr. Jackson has been a model citizen since he's been in custody. We obviously have some issues that we have to resolve, some of which he's already resolved, but for whatever reason, there's been a clerical hiccup that we'll have to figure out.
You're referring to a hold in College Park and one in Anniston, Alabama?
Well,
or something else?
Carroll County case with regard to the Coweta and Troup County cases, that should all be resolved. The
They put a hold on me from January 2021. It's an inter from January 2021. I've been in custody the whole time.
there's some outstanding issues that we think would be exculpatory with regard to those charges, Your Honor. I haven't been retained on that, but there have been some.
In Carroll County?
No, in the hold in Alabama.
Oh, in Alabama. Okay.
And I believe Ms. Convery might have mentioned the warrants, but there hasn't been really any action on those.
The warrants meaning in College Park? Okay. And they're older. The Anniston one is newer, but Mr. Jackson will work through that. He may get a trip to Anniston, or you may be able to help him out with that.
Correct, Your Honor. So we just respectfully request that this court accept the negotiated plea that we have worked out with the state, given the charges here and given the facts. We won't go into what potential rebuttals we might have, Your Honor, but I think that it's a reasonable recommendation, and I thank the court for allowing us to come before you and to work out that latter part of the sentence so there wouldn't be a conflict later.
Sure. Mr. Jackson, you said you've had some college. Where'd you go to college?
Dalton State University.
For how long?
Almost a year.
What did you study?
Criminal justice.
Well, that's interesting. Subject matter expert. Why'd you stop?
I had to come back home and help out with the family, and I had a child.
How many kids do you have?
One.
Boy or girl?
Girl.
What's her name?
Skylar Denise Jackson.
Skylar. And Skylar must be at least 3.
6.
6. Wow. All right. And she stay with her mom?
Yes, sir.
Well, that was sort of a yes. Where does Skylar tend to stay? I mean, obviously not with you.
She lives with her mom, but yes, yes, she's back and forth.
Okay.
With my family.
Mr. Hiles, I assume there's no restitution. You didn't say anything in connection with the Infinity, or I don't remember what the other car was in 993, but you hadn't said anything about restitution. I'm fine with that. I just don't want that to pop up later on.
No, there's no restitution due.
Okay. All right, Mr. Jackson, do you have any questions about anything that we've been talking about? It's been a long conversation.
No, sir.
Okay. Well, I find there's a factual basis for each of your 3 pleas in the 3 cases. And I also find that your pleas are knowing and voluntary. Voluntary means no one's forcing you to do this. You've had a chance to confer with your lawyer and family and anyone else, and you've decided it's in your best interest to move forward with the 3 pleas. Is that correct?
Yes, sir.
And knowing just means that you've understood everything, and you have, I've watched, turn to Mr. Jones as I asked you to, and asked him questions throughout this conversation that we've been having, and you told me you don't have any other questions. So I find that your plea is knowing. I am sentencing you pursuant to the Probation Options Management Act. And all that means is that for the time you're on probation in Fulton County, if you have what we call a technical violation, which is a minor violation, maybe you miss a meeting, or you move and you don't tell probation that you moved and they struggle a little bit to find you, that kind of violation, you and probation will work out. But if you get arrested for something again, that comes back to me and we'll work through it. So if it's serious, you come back to me. If it's minor, you and probation will sort it out. Okay?
Yes, sir.
All right. Now for sentencing. I'll start with 18 SC 162228. There is, let me get the indictment in front of me. So count 1 is being dismissed. Counts 2 through 6, your sentence is 5 years to serve 3, with the balance on probation, credit for time served. 8 is being dismissed. 9, your sentence is 5 to serve 3, balance probated. That'll run concurrently with count 2. And I should have said counts 2 through 6 are all concurrent with each other. 9 is concurrent with count 2. Your sentence on count 10 has to be 5 years. It has to run consecutive to count 2, and I'll suspend it. Counts 11, 12, and 13 merge into count 10, and 15 and 16 are being dismissed. And the other counts that I didn't mention don't apply to you. In 18 SC 163993, your sentence on counts 1 and 2 is 5 years to serve 3, with the balance on probation. Those will run concurrently with each other. And counts 3 and 4 are each 12 months to serve. Those will run concurrently with count 1. And your sentence in that case runs concurrently with the case ending in 228. And finally, in the 19 SC case, 19 SC 168784, you're charged in 3 of the counts. Count 1, the sentence is 5 years to serve 3, with the balance on probation. And counts 3 and 5 are misdemeanors. Those are 12 months to serve. Those will run concurrently with count 2. And your sentence in this case also runs concurrently with the sentence in the indictment ending in 228. The sentence I've just pronounced I intend to represent a term of 10 years to serve 3, followed by 2 years on probation, and then 5 years suspended. If the Department of Corrections does the math and it's anything longer than any of that, they've done the wrong math, or I've said something incorrect and we need to fix it. And finally, your sentences in Fulton County will run concurrently with any sentences you are currently serving in Coweta, Carroll, and Troup counties. And we'll need to get the indictment numbers for those cases so that we can put in the appropriate place on your 3 Fulton sentences that they are to run concurrently with those sentences in those counties. I didn't hear anyone from DCS or pretrial services say you had a case in Troup. I believe you, you'd know better than anyone else, but they didn't mention that. And it sounds like Carroll may have gone away, but everyone had heard about the Coweta case. And I will say this, I think you need more than 2 years probation, because I think everyone needs to see that when you get out, you're going to be a father and a brother and an uncle or whatever's going on, and not the knucklehead who was involved with these cases. Because if you get picked up in 6 months, driving a stolen car with a stolen gun, hanging out with some of these guys, I'm going to revoke as much as I can. I don't think 2 is enough, but I don't want to upset the negotiations. And Coweta has you on probation forever, and they will revoke everything and throw away the key because they play harder than we do. And I trust you know that. So if you remain a knucklehead and not a criminal justice student at Dawson or taking care of your family, I can do a little bit. Coweta will do a lot. And I am comfortable knowing that because they don't goof around. We don't goof around either. We have a lot more folks we're working with. And so it requires a different worldview if we're going to keep the system running. I hope the best for you. 3 years in county jails is crummy. You've missed your daughter half her life. You've missed half her life. And I hope you want to be present in her life, and you got folks who care about you and you want to be around them. But you're a grown up. You control it now. They can hold your hand, but they can't keep you from doing stupid things. So just be thoughtful about who you run with when you get out, because there are folks who care about you in a way where they'll help keep you out of trouble. And there's some who are going to say, hey, let's go for a ride. And you know what they mean, and you know where they're going. And if you go for that ride, blue lights could show up, and then Coweta will be waiting without a big smile on their face. Mr. Hiles, anything else one last thing. I've got 3 indictments that I'm going to sign electronically if you authorize me to sign them on your behalf, Mr. Jackson.
Yes, sir.
Mr. Jones.
That's fine, Your Honor.
And Mr. Hiles. Okay, so I'll sign those. That'll take care of the indictments indicating your guilty plea and what counts are being dismissed. I don't have anything else. We're going to need to get some reporting instructions for you. So for probation. So Ms. Tucson's going to talk to you in just a minute. Do you have anything else?
I apologize. It's been a couple of years since I've taken a plea on a gang case. But by statute, it's required that one of the special conditions be that he has no contact with any known gang members.
Okay.
I did not bring that up earlier, but that is a part of the statute. So I don't know if that has any effect on what you'd like to do.
Well, it has an effect in that I need to set as a special condition in 18 SC 162228 of your 2 years probation that you not have contact with any known gang members. That's a complicated term because you've just heard the state say, like, your brothers or whoever your relatives are, they're gang members. Are they? I don't know. That hasn't been proven. But let me say this. You don't need to defend them. I'm not passing judgment on any of them. If you know some of the guys that you might hang out with are saying, hey, we're part of this group, don't hang out with them. I'll tell you what, one of the things probation is really good at is sort of staying current on what law enforcement thinks the different groups are. Call them groups, call them gangs. And they're going to know, hey, this guy's hanging out by the green store and he's with all these guys who are part of the YSL, whatever it is. It's just not worth it because they snap a photo that goes to Mr. Hiles. He's the gang prosecutor. And I say, wait a minute, look who Mr. Jackson's kicking it with. And that will be a reason to revoke your probation. And it has to be a special condition. And all special means is that kind of violation I can revoke all your probation. One of these technicals, you test positive for something or you miss a meeting, there's a limit on what can be revoked. And frankly, revocation doesn't make sense. It's let's help you out. But if there's picture of you on Instagram that is dated after June of 2022, and you're doing the signs and you're holding the gun with some other guys, that picture speaks 1,000 words and 2 years revocation. Done. I mean, it's that easy. Oh, that's not me. I'm the one who decides if it's you. And I've spent some time. That's Mr. Jackson. And it's a real short conversation. And then Skylar gets 2 years older without her dad around. So resist the temptation. You've been away from folks for a while. Hug the family. You may have to have some folks that you just keep at a distance. And that's how you got to roll for a little while. Any questions about that?
Can I hug my family before I go back?
That you can't do. What Deputy Gordon will let you do is say hi to them. You can turn around and say hi to them, but sheriff doesn't allow contact things. Just you understand why, security reasons. They give you a big hug and all of a sudden in your back pocket, they say, hey, it's handcuff key. So we don't want that to happen. But you can certainly, you're going to be getting out real soon if you've done almost 3 years. So I would say before 4th of July, you'll be hugging your family. Don't quote me on it. The guy who will keep us honest is Mr. Jones. If the math is you've done more than 3 years, at least on these Fulton cases, you need to get out. I can't speak for the other jurisdictions. And I just forgot, if you've got holds, you're going to need to deal with those because the sheriff will say, I did the math. That's 3 years. Anniston, what do you want us to do with Mr. Jackson? And if they want you, then you'll go over to Anniston. Fortunately, that's not California. It's not too far away, but those holds will have to be cleared up before you can be released. But that's why you got the guy in the suit standing next to you. Okay. All right. It's all right if he turns around and says something to the family. Keep it clean.
Love y'all.
All right. Good luck, Mr. Jackson.
All right. Thank you.
You're welcome. So, Mr. Jones, we will get those final dispositions ready. They'll take a little while because that was a lot of counts. But we'll hold off for you and Mr. Hiles. Sounds like he's got people in one of those counties just to get those case numbers so that we put that in the special instructions box.
Yes, Your Honor. Thank you
Okay.
very much.
Oh, right. I'm sorry. I forgot. He can just come near a microphone. I'm sorry. Ms. Tucson, you still with us?
Yes, I'm here. I was just going to ask him about the address I have on file, and if that is not correct, something, current.
Okay. You can go to that microphone right there, Mr. Jackson. We just need, because you may get out soon, you need to get some probation reporting information. So take it away, Ms. Tucson.
Okay. Mr. Jackson, is your address on Ben Hill Road still?
No, ma'am.
Okay, I'm gonna get the updated address from you, so that way probation has it on file. What is your address that you currently have?
I'll get it, Your Honor. Just give me 1 second.
Okay.
Okay, so the address I have is 950 Biloxi Boulevard. That's Buloxi Boulevard, Riverdale, Georgia, 30296. 296.
And just repeat the first part, just so that way I make sure I have it and type it in.
That's fine. 950 Biloxi, Buloxi Boulevard, Riverdale, Georgia, 30296.
All right, and just a good contact phone number. Not sure if you'll have it when you are released, but just something we can have on file that's updated, because we might have an old one on file as well.
404
Mm-hmm.
683 9344.
Okay, and do you know where the probation office is in Coweta?
Yes, ma'am.
Okay,
No.
because that's since on 51 Perry Street in Noonan.
Yes,
Because,
ma'am.
these are Fulton cases, they will be in your file, but since you're gonna be living still in that district, you're going to want to report there, but they will have all this case information. And failure to report after you're released will result in a warrant.
Yes, ma'am.
How do you have a phone number after being in for 3 years?
It's not my phone number. It's an emergency contact for.
Okay, but it's a good number where
it's a good
someone will
number,
get you.
yes. Yes, it's
Okay.
a good number.
Got it. Okay.
And Your Honor, just really quickly, I was just informed that Mr. Jackson was banned from Coweta County, so he won't be reporting to Coweta. We have to figure out whether we need to transfer it over to. Oh, it's already been transferred? Oh, okay. He informs me that it's been transferred, but I know that
I just ain't been able to report because I ain't been out yet.
okay. You know where it's been transferred
Well,
to?
then you would report to 276
Email
Memorial,
Martin.
and then they'll give you further instructions.
Yeah,
from
why
there.
don't we do that? That's just safer. I don't, the last thing you want is to get sideways with Coweta day one you're released. So let's have you report to probation here in Fulton, and they'll figure out how you'll be supervised. So could you repeat that address, Ms. Tucson?
No problem. It's 276 Memorial Drive.
It's like 3 blocks from here. Is not far, but it is where you'll need to go. So that address that you read is not in Coweta County?
No, sir.
The Biloxi?
No, Your Honor.
Okay.
No.
Then why were we reporting to Coweta County? Oh, because there was other probation there.
Correct.
Yeah, let's stay out of Coweta County.
That might be Clayton County. That Riverdale address is Clayton. But either way, when you report, they will let you know what county it is. But report to 276 Memorial Drive 30303.
It's a hot date. Don't miss it. All right.
Thank you.
Thank you, everyone.
Thank you, Judge.
I think that concludes our calendar. Ms. Jackson, we were not able to reach Mr. Granum's. But again, he sent us proof of his situation. So we'll circle back with him to figure out what he wants to do next. Well, what he needs to do next is connect with Mr. Hiles, the prosecutor. And I now understand a whole lot more about this case and the facts and circumstances of it. And a whole bunch of folks got arrested because of what was going on in one house. And there's some defenses of merely present and whatnot. But that's the kind of thing that Mr. Hiles understands based on how he handled. Is that your brother? Your brother's case. So Mr. Hiles needs to talk with Mr. Granums. Mr. Granums needs to talk with you. And then we'll get you back here soon to see if we can get closure in your case as well. In the meantime, you'll remain on the big old bond that you have. Okay? Any questions? All right. And we have a good address for you? Yes, sir. Okay, excellent. You guys have any questions about anything? No, sir. All right, thanks. Thank you. Are you all summer interns? Yes. You guys have any questions about what happened?
It was self-explanatory. Thank you, Your Honor.
All right, it actually wasn't so self-explanatory because that was a complicated bunch of cases. Normally, it's one case, one plea, 3 counts, but poor Mr. Hiles had to go through a whole lot of stuff, and he has just these are old cases. Also, normally the cases are not 4 years old. You may have heard the May 2018. What? A problem that we've had is that multi-defendant cases don't always have. Are you retained on this case?
Which case is that, Your Honor?
Mr. Jackson's cases.
On
any of them were you retained?
Yeah, I was.
Yeah. Okay. So normally we don't have retained counsel. Most criminal defendants in Fulton County are indigent. But if there's only one defendant, we have phenomenal public defenders. They take the case and that's great. When you get on beyond 2 defendants, we rely on a shrinking universe of what we call C3 lawyers who take appointed cases. And we had 4 good ones and they all quit. And so there's actually a co-defendant here, Mr. Chambers, that I was asking Ms. Nelson about. He's got no lawyer. He's been in jail for a few years and his lawyer quit because lawyers can do that when they're appointed. And so we're trying to find a lawyer for him. So this case got old, COVID, it got old because we can't find lawyers for a couple of co-defendants. Normally, they're not that old. We're taking pleas in 2022 for something that happened in late 2021. But otherwise, it is self-explanatory. This is sort of what a criminal plea is like. That's it. Did you have questions?
I did.
Yes, ma'am.
How often do you change a negotiated plea?
I was really tempted to change this one to add more probation. That's all I wasn't going to add more time. 3 years is plenty for what this guy pled to. You know, if someone had been shot, I'm like, hey, 3 years is too little. This needed more probation, but I had CAUIDA. So I would have turned some of that suspended sentence into probated. So it probably would have been 8 serve 3, 5 on probation, just so that Mr. Jackson has some time where I could reel him back in if he reverts to this format. I don't know what he'll do. He's still real young and he's got a loving family, but he had that loving family when he was rolling with all these people. And it's just all too common that we say, oh, it's your first offense, we'll give you probation. And 6 months later, we're back with the same thing. Because it's hard to learn. And frankly, there's not a lot of good structure out there. The structure is this guy's friends. So we'll see. Maybe Skylar will affect him, but I'm pretty comfortable adding more probation, adding more prison time. I have to be thoughtful about it because it can also blow the plea up. But that's all right. If I think that that's not a reasonable sentence, the buck stops with me and not with the lawyers who negotiate it. So every once in a while, I'll say, you know what? You fired a gun and you hit someone and you're lucky they're still alive. I appreciate the person's not dead. If the person's dead, you're looking at life and the state just offers you 2 years. It's not a 2-year case. If you want to plead, it's 8 years. Oh, I don't want to do that. But then come back and they plead because they don't want to go to trial because then it could get real messy. So, sure. All right.
My business is concluded.
Yes, no one else is trapped in here. It's the interns. I always like to let them ask questions because they don't always like, hey, well, why did the judge do that stupid thing? I'd be happy to tell you why it wasn't stupid. So, all right. Thank you for handling all these things. Get us those case numbers and we'll take it from there. All right. You are not free to go, but everyone else can go. Let me end the Zoom, or is this Zoom carrying over? I will not end it. All right. Great question. The status conference calendar, does pretrial need to be there? I don't think so. There's nothing that's going to be a plea. So I think both the birthday girl and Ms. Roberts, you are free to go. If for some reason one of those statuses turns into a plea, I assume we've got a 1-900 way to reach you all to get your valuable information. Yeah, could we also have motions?
I'll be in the office, so.
Okay, so you'll be findable. And Ms. Roberts, if we need to find you, we can just shoot you an email.
Yes.
Okay,
I
we'll
want my
do
email
that.
in the chat, but it's nakia.roberts@fultoncountyga.gov.
Good. We'll do that. But for now, assume you don't need to dial back in. The motions hearing will be fascinating, but not resulting in a sentence. And I don't think any of these statuses will either. Thanks. You guys have a great weekend if we don't bug you again.
Judge.
You too.
Ms. Wood.
Hi, Judge. How are you?
I'm well. How are you? I'm just going to
I'm
stay.
good.
I'm still here.
Is Miss Nelson in the courtroom?
Always. She's right here.
Can you ask her? There was an email late Wednesday about a gentleman that's in custody in the Virgin Islands. It was Miss Nelson, Miss McCauley, and I on the thread. I just wanted to see if that person was going to be able to Zoom in today.
He's in the Virgin Islands.
It sounds like you and Ms. Nelson will need to talk offline because
Okay.
She's wearing a mask, but I'm getting a confused look.
Okay. That's fine, Judge. I'll see you at 1.
Okay, thanks.
Thank you.
Yeah, I'll go call him.
All right, let's go back so that our conversation is not broadcast all over the world.
But, sorry, investigator Cross.
Oh yeah, he can come too. We're just gonna talk about prioritization and where certain cases are going. Nothing specific. We're not gonna have defense attorneys there, so just structural stuff.
Luckily, quite familiar with most cases. I was in the gang unit for about 2.5 years.
That's what I heard.
And then a lot of the cases I worked on the indictment of anyways.
All right, I'll be there in 1 second.
All right.
So I didn't watch the fourth quarter, and so I was just now figuring out what the heck happened. Come on. You were asleep apparently, so same deal.
Heard, the only way 7 shots.
Yeah. I mean, that's what went on. And the Celtics did everything. They were deadly. Tatum was terrible, but everyone else from in the threes, it was raining. That's no good.
That's the thing with laws. They either on or off.
Yeah.
No in between.
All right. So 1 o'clock, we've got some folks who are in custody. And then when we finish that, we got a hearing, guys not in custody, but it's a criminal case. So we'll need you this afternoon and anyone you can convince to be here with you.
Trying. Work it out, work it out, work it out. Oh.
All on the TV outside. Let me tell it.
Oh, you got it?
I'm going down the back, so I like to my way down. Which one? Yeah, I just said, I was surprised he stepped. He was just gonna tell. He forget, he gonna do it again. Yeah, of course. He's making himself a criminal. And he said he went to school. That was fun. I wanna believe it. You think so? Yeah, everybody. He has stolen somebody's cars. And if it ain't cars, it's that's why I was seeing here, it's something with stealing. That's what they do. They steal a car and try to make money off it. Chop shop. But, all right, I'll be back. Yeah, that was wow right there. I was surprised. So it's lucky and then you got this out here. She said she wants her shift. No shift. The numbers?
Yeah, the numbers or something till we come see me, but I got too much stuff to do. I'm not going to do that right now.
The funny part is that no one else in there did it anyway either.
You said nobody was?
Nobody else did it either.
For real?
No. Not Travis, not, no, just get shit out of me.
And I'm sorry, Mr. DA, what is your name? again?
Hey, I'm Reeves Hiles.
Reeves?
Yes.
Hi, I'm Deidre Nelson.
Nice to meet you, Ms. Nelson. Sorry.
All I request is that you just answer my emails.
I'm good at
Oh, yeah,
I'll bring it back to you. I'll bring it back to you. All right, great.
I want to go there, but I know they're going to talk, because I need to get this car fixed before we come back for 3 o'clock.
No, I'm just gonna go,
So just go holler at her. I'm not going up there. Yeah, just do the number. She was like, okay.
I'm just gonna do it. When's your meeting with Bonnie? It's not today.
Who, hers?
Yeah.
I think it is. Oh, man. I think yeah. He's busy there. You know, someone get off. I said, let me get out of here. I'm going upstairs to check my reading.
No, I'll do it.
What happens when you go to work and go to your minutes? I didn't even hear it. Well, you for your computer? I did. I need like 2 screens and try to. All right.
Yeah, bathrooms.
I could go get one, cause I know y'all from this correct.
What you go ahead and do it. I just need to do it whenever you get a chance.
Alright, tomorrow to office,
Yeah.
alright.
6-0-1300. Go ahead, go ahead.
What time y'all think y'all gonna be out so I can go in there also?
Yeah. We got something at 1:30 and 3. We should be done about 3 though.
I had already made it down. I heard y'all walking down.
Which one you was at?
I came out of AB.
Hey, you?
AB elevator.
Oh.
How are you?
So I'm gonna like sit right here. Britta, you can sit here if you want to.
Okay.
Leanne steered this ship today.
You know, I don't know what you think, so there's just not.
I know I have one. So
What is this calendar? Status?
it is a status conference plus a motion.
What's the motion?
It's a Jackson Deno and
How about a state though?
Yeah.
Actually, I think not even, wow, I mean, probably.
Oh,
right.
But remains 16, but that's gonna be here.
oh,
Yeah.
Okay. Okay. Famous games? I'm coming to talk to you.
The DH is zooming in like this.
I will be surprised, but maybe.
Otherwise, we just. So I just want to know that you're here. I know we'll go here, then it won't take long. So what is this table?
So it hasn't always been, I want to say, these, like during, like when courts started opening back up after the pandemic, these tables were facing like each other. So like this one was turned that way, that one was turned that way. So I'm honestly not sure.
Hello.
Hi, Ms. Nelson.
You see, like it's in a weird spot, and it's the only table that doesn't have a case on.
Yeah.
So I don't know, I've always been, I've been looking at 2 days.
I'm not sure. That's a good question though. Oh, you know what? Might have been, there was a trial in this courtroom with co-defendants, and I think they might have brought it in here. I think that's why.
That could be,
Mhm.
yeah, just like.
Yeah, because they need
On
it.
this side.
Yes, I think that might be it.
Okay. And what's the like lower, like, right here?
So the court reporter, if she's in the
She's
courtroom,
the
she'll
court,
sit
she's
there.
there,
Mhm. You have so many good questions. I love it.
Thank you. I'm just curious about things as rather than.
No, that's awesome.
I thought the calendars were out here. Be right back. Stacy. All right, good afternoon, everyone. We have for our 1 o'clock a series of status conferences where I would like to hear from the prosecutor and the defense attorney how we are doing in terms of being ready to go to trial on a case. Our first is Mr. Connor. Is Mr. Connor here? All right, can we bring him out, please?
I'm not sure who's handling that for the state. It's emailed with Ms. Patel, but I don't see her and I'm not sure.
Mr. Thomas is here, and he represents the state, so we'll assume he's gonna rock and roll on this one.
Yeah, I can stand in. If I'm taking announcements.
Okay. As long as you're going to say the word ready, I guess it's all good from the state side.
That's what I'm trying to figure out right now, Your Honor.
All right.
He's right. Yeah, he's fine right here. Thank you.
Mr. Connor?
Yes.
Good afternoon, Ms. Rivers. Are you ready?
Yes, Judge, I'm ready. Good afternoon.
Great. This is the status conference in State versus John Connor, 18 SC 162181. Mr. Connor's case, I think, was about ready for trial from the state side. I know there had been transition on the defense side, and so I'm going to want to hear about that. But if I'm remembering, something about a statement Mr. Connor made, and there was a representation, either the state was not going to use that, and I'm feeling like it was Shamal Patel who was saying these things, but I'm not attributing it definitively to her. And Ms. Feely, I'm going to let you get us up to speed on that. But I don't think with Mr. Connor we needed to have a Jackson Deno. There were two cases where sort of out of abundance of caution, we were going to do a Jackson Deno. One of them is this afternoon with Mr. Mitchell. I can't remember if Mr. Connor was the other one. But really what we need to work through in the next few minutes is what, if anything, beyond Ms. Feely's very necessary need for time to get familiar with the case file, get to know Mr. Connor, et cetera. What beyond that stands between us and a trial date for Mr. Connor or a resolution? So I'll start with you, Ms. Feely, because Mr. Thomas is hoping he can get an answer from the state side.
Yes, Your Honor. So Your Honor signed an order May 4th of this year.
I'll make sure your microphone is on, and if you just have it angled towards you a little bit. Thank you.
Kind of a denial of a motion to suppress based on the state's representation that they didn't intend to use the statement.
Okay. So I am remembering that the state represented, we won't be using it. And so rather than the motion being withdrawn, I denied it as moot. Okay.
Right. So that has been litigated at least. And so from a preparation standpoint, Your Honor, I think we could be ready to go on this case. There's a couple things. I was unable to meet with Mr. Connor until this week because he was, it turns out, incorrectly listed as in medical holding. But I was able to meet with him this week. But I have not had a chance to have a meeting of the minds with the prosecutor to see if we can resolve this in a more efficient way. And I would like the opportunity to do that.
Who is it that you understand to be the prosecutor?
I thought Siri Patel.
Okay.
And it could be that was my error, and that is.
Let's ask Mr. Thomas. Mr. Thomas, can we at least get that from the state, the identity of the prosecutor?
Yes, Your Honor. It's my understanding it is Terry Patel, and she is in the courtroom right now.
Fantastic. Well, we may be able to do a 2-for-1 here because Mr. Connor's case is also on we have this 3 o'clock, and some of you may be saying, what's the difference between the pretrial and the status? For Mr. Connor, there's no difference. It is, I had asked Ms. Nelson to put some of these cases on status conferences. And then just because we've got that 29th calendar jury selection date, we needed to figure out if there was anything that prevented this case and others from being on that. So we'll get Ms. Patel in person real shortly. But other than you, Ms. Feely, wanting a chance to talk with Prosecutor Patel about a non-trial resolution, you've got the discovery, you've had a chance to connect with Mr. Connor. You'll have additional chances, obviously, between now and a trial date. Is that June 29th jury selection date, which would be almost 4 weeks from now, too soon, or is that something for which you think you could reasonably announce ready?
I think it's ambitious, but I definitely think it's a possibility that if I know this case is going, that I would be able to be ready. For scheduling purposes, I would like to bring to the court's attention that Mr. Connor has unfortunately been diagnosed with stage 4 Hodgkin's lymphoma, which does involve him going to treatments, and he is starting chemotherapy. He's actually signing a release now so that I can kind of get more visibility on kind of when those appointments might be coming up. And Ms. Patterson is going to get those records for us, but that could be a challenge scheduling wise.
Sure. I am fortunate to know very little about what you just described and its meaning. Stage 4, as I do understand, the higher the number, the more advanced it is. Is a Hodgkin's lymphoma scenario one where that is life-threatening? Because you can have stage 4 of certain cancers and that's the wrong stage for you. You don't want that stage, but in the end, it is a treatable, curable. Science tells you don't panic too much. Whereas others, stage 4, that's a really sad development.
So I hope to be able to get some more documented proof, but from Mr. Connor, his understanding is that while it is aggressive, it is treatable. And so there is, obviously he's continuing to be tested to see the spread and all of that. So, but the word treatable, I think, is encouraging. It
is encouraging. Then what we would need to work through is what treatment means, by which I mean for right now, if Mr. Connor would be undergoing that treatment, which he should, would he be in a position to assist you and make it through a week of trial because it's demanding? And if that's not where he is physically and mentally because of the treatment, that's a factor for us to consider. Another way to think about it is, boy, we better get this trial in soon before he needs to commit himself to the regimen of treatment that may be prescribed. All right. Well, Ms. Patel has just joined us. Hello, Siri Patel.
So sorry, Judge. I got the times mixed up.
That's okay. Mr. Thomas was covering for you and was saying, hey, I'm happy to try it if Ms. Patel can't. But all we had covered was an update from Ms. Feely that she's had a chance to meet with Mr. Connor and feels like she's getting a much better understanding for what this case is all about. That she said it would be aggressive on her part, but she might be in a position to say ready to try on June 29th, because that's our next jury selection date. And so now I'm bleeding over from status conference to the 3 o'clock. So if this is your only case on the 3 o'clock, you don't have to plug in on the 3 o'clock. But what Ms. Feely said she really needs to do next is meet with Siri Patel. So let's make that happen early next week so that you all can start to talk about, well, where are we on the spectrum of resolving the case? Ms. Feely just shared in a public setting, so I can share it with you, that Mr. Connor has been diagnosed with stage 4 Hodgkin's lymphoma, which is serious but treatable. And he is either has begun or will soon begin some treatment, which could make somewhat complicated being in court. I don't know what all is involved in the treatment, and we don't need to get that on the record here. But Ms. Feely hopefully soon will be in a position to advise as to what trial would look like for Mr. Connor, if it's going to be a trial. Obviously, if it can be resolved, all the more reason to try to do that so Mr. Connor can focus on treatment, whether that's in the Department of Corrections or back home, wherever home might be, depending on how things are resolved. Ms. Feely, anything else we ought to know about in terms of you being ready to defend Mr. Connor at trial?
No, Your Honor, I think that's it.
Okay. Ms. Patel, I was reminded that based on your representations when we last talked about the case, I entered an order saying we don't need to deal with the motion to suppress statements because the state has said we're not going to use them. And so that's still the state of play. Anything from the state that would prevent you from, or Mr. Thomas, announcing ready to proceed to trial on that June 29th date?
No, nothing from us. There is potentially a 413 victim. This is just someone we had been trying to find for a very long time. We finally did find them and were able to hash out a little bit more what happened. So I may be filing the 413. I know that's outside of your order, but this is something that we didn't really discover until recently.
So the order is based on things you already know. If it has only recently come to light and you can document that, then we just need to jump on it so that it is not an eve of trial thing. And if we need to have a 413 hearing, we can. As you know, that's a less steep hill for the state to climb than a 404B. But I would certainly want Ms. Feely to get from you any and all information you've got, because that I assume would factor in pretty meaningfully with her discussions with Mr. Connor. Yeah, I know the state is offering this. That seems like a big number, but with this 413, your outlook just got more grim at trial.
And I'll make sure that's done by end of next week at the maximum.
Okay. And you could even, if I'm hoping before the end of next week, the two of you speak during that conversation, you could at least informally share, look, there's a young lady who says X and Y, and we don't have these things yet, but we're going to get them. Because even armed with this is what the information will show, Ms. Feely can be in a much better position to counsel Mr. Connor.
Absolutely.
Okay. So maybe 413, we've got a health situation with Mr. Connor. State will be ready. And then Ms. Feely, I'll just ask you, if something fundamentally changes, I can't be ready. I'm going to put this as could be ready. But what we'll do after we've talked about all your cases is take a step back and say, all right, knowing that you are aggressively charging up a hill, a learning hill on all of these, which one or two do we want to know? Yes, you'll do it, so that on June 29th, I don't have a day with no jurors, but we are advancing a case that is old and ought to be tried. Does that work?
That sounds fair, Your Honor. Thank you.
Mr. Connor, do you have any questions of me right now? Today is just procedure. We're not talking about the substance of your case.
No,
Okay. When have you already begun treatment, or you will soon?
I was supposed to start it last week, but because of the mix-up, as Ms. Feely said, they apparently, I guess, lost in the system.
They couldn't find you.
And
Sort of ironic, since of course you've been in the same building for a bunch of months. Okay. All right. Well, please keep Ms. Feely posted, or Ms. Patterson, team member, whoever's reaching out to you on how that's going. We will not make you go to trial if you are, because of treatment, not in a position to meaningfully assist your lawyer. But you are certainly entitled, in a case that was indicted 4 years ago, to have your day in court. And I'm pushing hard to make that happen within the bounds. All right. Thank you both, Ms. Patel and Ms. Feely. All right. Our next matter is Ms. Scott. Is Ms. Scott here? Hi, Ms. Scott. Is Mr. Adams your lawyer? Oh, but that's why Mr. Mallon is on, his delegate from Provence.
Yes, that is correct, Your Honor. Good afternoon.
Good afternoon. Ms. Scott, come on up to the podium, please. Do we know where Ms. Charles is? I bet she thought it was at 1:30. Because I'm assuming this is Ms. Charles's case. So Ms. Scott, we're just trying to figure out where the prosecutor is, and then we'll hear from Mr. Mallon, who is associated with Mr. Adams, as to where your lawyers are in terms of being prepared and where the state is, because based on my notes, your case should be ready for trial. It's yours. Oh, okay. Got it. Well, that would explain it. But ultimately, we'll get to position 4, and that is definitely Ms. Charles's. So hopefully she's heading this way. So Mr. Abate, why don't you come on up to the state's table? And we're going to start with Ms. Scott. We'll work with Mr. Watson in a minute. All right. So starting with the state, have you had any issues getting discovery to Mr. Adams? Either because you don't have it or you get a bounce back from his email?
No, Your Honor.
Okay.
I believe Mr. Rao had served, I know Mr. Rao had served all the discovery within the state's possession a good amount of time ago. So he has it, is what I'm trying to say.
Mr. Rao, your predecessor.
Yes.
Okay, got it. All right. And state's ready to move forward, would this be a trial of Ms. Scott and Mr. Watson together, or do you envision there needing to be a severance, or at a minimum, Ms. Scott's case is going to be resolved short of trial?
That, the last would be what I think, that Ms.
Okay.
Scott's case would be resolved short of trial.
And Mr. Watson would go to trial if he does solo.
Yes, Your Honor.
Okay, all right. Mr. Mallon, from your review of the case file, anything outstanding from the defense side, or this is a matter that we could move to a trial calendar?
Not that far. I can confirm that Mr. Adams has received discovery. But my instructions are to request that it be put on a final plea calendar. There hasn't been an offer made, and as Mr. Abati correctly anticipates, this should be resolved short of a trial, with or without a severance motion.
Got it. So we don't do final plea calendars anymore. We have a status conference where we talk about where things are, and then we'll move Ms. Scott's case to a trial calendar. That ought to be a spur to both sides to have a conversation about what they might want to do with the case. And if it is going to be resolved short of trial, we will make time to have Ms. Scott come on in and resolve the case short of trial. But the next destination for this case would be a trial calendar. Now, I will note that her co-defendant, Mr. Watson, is about to get a new lawyer. If Mr. Watson was represented by Mr. Tertiary as of just a few days ago, because there's been a change in personnel on the conflict defender side, which will slow things down a little bit. And that means there ought to be ample time, whether it's you, Mr. Mallon, or Monsieur Adams, who will be handling the non-trial resolution for Ms. Scott. But you all know where Mr. Abate is. He's not hard to find. If there's something that folks want to try to work out, they are in a position to do that. Did you have anything else from Mr. Adams, or it was simply not so fast a trial calendar?
Not so fast.
Okay. All right. Ms. Scott, do you have any questions?
No, I just bring you back my paper with me and you talked about last time I had got approved for the house.
Oh, all right. That's good. Is everything going all right on the outside?
I'm a manager overnight at Crystal's, and I work with this lady. I'm a caregiver.
I was going to say, you don't look dressed for Crystals. You look dressed for being a caregiver.
I work overnight for that Crystal's.
All right. So you work a lot.
Yeah.
Is Crystals 40 hours a week?
Yeah, now because I'm a manager.
And you're doing the caregiver situation.
In the morning time, 9 to 5. I go to Crystal 10 to 7 in the morning.
And when is it that you sleep?
I sleep.
At Crystal?
No, well, I can if I want to.
Okay, well, I guess managing has its privileges. Okay, well, I'm glad you're doing all that stuff. You keep abiding by the conditions of your bond, and your two lawyers, Mr. Mallon and Mr. Adams, will be getting with Mr. Abate. And you're still at the same address? You got something in the mail to get you here, or that's why you're telling me?
Yeah, I got something. I'm at the same address until they give me a move-in date. I just signed my papers down at 10 Park Place.
Well, when you do move, make sure you bug your lawyer, but you may even want to just yourself contact the clerk's office to say, here's who I am, this is my case number, I've got a new address. Because they look into the system, they don't look into the phone book. We don't have phone books anymore. They don't look online. They're going to send it to your old address. And if you didn't update it and you miss court and there's a warrant, that's messy. So when you do move, and I hope you do soon, just make sure you push that information to the clerk's office.
Yes, sir.
Okay, great. Mr. Abate, anything else in Ms. Scott's case?
No, Your Honor, I will reach out to Mr. Adams first thing Monday.
I don't know that he'll be back. He is abroad right now. Mr. Mallon, did he reveal a return date?
I believe it will be, what is the date of next Tuesday? Is that the 6th?
That's Monday.
Monday. Well, Tuesday is the day he said to me, and I'm sure he'll have jet lag from all that French food.
Okay. Well, all I know is Miss Scott's paying him too much if he's in France and she's here. But it sounds like
Yes.
yeah. sometime next week, Mr. Abate, if you don't mind reaching out to Mr. Adams, see where everyone is.
Yes, Judge.
Great. All right. Thank you, Ms. Scott.
Yes, sir.
You are free to go.
Yes, sir.
Don't lose your papers.
No wrong.
Have a nice weekend.
Yes, sir.
All right, thank you, Judge. That concludes my business. May I be excused?
Yes, sir. Have a great weekend.
Au revoir.
Yeah, you too. All right. Mr. Theory was going to join us. So we're going to reach out to him before we bring Mr. Watson out. So why don't we switch to, do we have Ms. Charles yet? No.
Charles is on her way, but she said Gaines does not go on.
Oh, who has Simone Gaines for
That'll be
the,
mine, Your Honor.
Mr. Thomas? We got who we need. Except, do we have Simone Gaines?
She's present, Judge.
Great. Ms. Gaines, if you'd come sit by Ms. Wood, please. All right, let's go on the record. Position 4, it's State versus Simone Gaines, 21 SC 179392. This is the status conference in Ms. Gaines's case. She's here with her lawyer. We've got Ms. Wood. We've got Mr. Thomas online representing the state. Ms. Wood, do you have the discovery in this case?
Yes, Judge.
I've got no evidentiary motions having been filed, which says to me, we can move this to a trial calendar. Any obstacles to that?
No, Your Honor, and I would like to, I got an offer from ADA Thomas right before court, so I would like time to speak with Ms. Gaines.
The classic right before court offer. I will remind all our participants, this calendar was published weeks ago. It's always easier if the offer comes a few days before the calendar, because then Ms. Wood and Ms. Gaines have a chance to talk a little bit more. But there is an offer, so why don't you all talk? Let me say one thing to Ms. Gaines. Here is Ms. Gaines, you are on bond, which is something you already knew. I want to make sure you are having no issue staying away from that address on Piedmont Road.
Yeah, no issue.
No issue? Was that a place you lived, or that's where those other,
That was, I previously lived there.
but you moved out?
Yes.
Okay, and staying away from Mr. Thomas and Ms. Clay?
Yes.
Not an issue?
Yes. Not an
Good.
issue.
That's the main part of your bond, as long as, oh, you're still wearing ankle monitor?
Yes, sir.
All the more reason to work this case out. But you're not paying for it. The county's paying for it.
Yes, sir.
Okay. All right. Do you have any other cases on the status calendar?
No, Your Honor.
Okay. In a minute, I'm gonna ask you two to talk. Mr. Thomas, anything from the state in terms of discovery? Whoops, we forgot we had this, haven't provided it yet.
No, Your Honor. It's my understanding that all discovery has been provided. So we're just waiting for them to consider our offer and we'll move on from there.
Well, you haven't been waiting very long because you just made the offer. But what we'll do is let Ms. Wood and Ms. Gaines talk. It sounds like state is ready. So if we don't resolve it today, just so everyone knows, the next stop will be a trial calendar. That doesn't mean you have to have a trial, but the next time I'd see you would be to say, let's go to trial, unless you've worked it out between now and then. And then I'd ask the lawyers just to get on a calendar with Ms. Nelson so we can sort this out. All right. Thanks. So if you don't mind staying on, Mr. Thomas, I'm going to let lawyer and client talk and we'll see what happens.
Yes, Your Honor.
Thank you. All right. So we need Mr. Theory or Mr. Cladis for two of the positions that remain, the only two. And we need Ms. Charles for one of them. Oh, you are here. Hey. You've got Mr. Holt.
I spoke to Mr. Theory yesterday. He said someone was bringing some information to him right around 2:30 today. I'm not sure it's been a little.
Okay. Well, I'll maybe be here and we'll see what happens. I mean, I'll be in the building. And it's Theory at 3 o'clock. We're supposed to talk about some cases.
I don't think it's ever like hold, I think it was 3 o'clock, so.
Yeah, today's calendars are a little confusing because there's overlap, like Mr. Connor's on both. We don't need to talk about Mr. Connor again. So if someone's only obligation this afternoon was Connor, you're not obligated anymore. But I see that Mr. Holt is there. So we can talk about Mr. Holt now or at 3, and it's not looking like now unless Mr. Theory materializes. Mr. Cladis will be taking that case over. And so we have the double whammy of, it's a little confusing with the calendars, and we are once again in transition with our conflict defender. Hopefully Mr. Cladis likes Atlanta and is going to stick around.
Yeah, I would bet they're gonna be here at 3. So
Okay.
They're leaving?
No, well, all I know, I can only speak from the very narrow perspective of the McBurney division because I fuss so much to Ms. Bernard and Ms. Ali, is that it doesn't work for poor Mr. Theory to have 9 courtrooms and all the major cases in 9. And there were some judges who had it like the old times, a conflict defender and only 2 judges. So now Mr. Cladis has 3 judges, squeaky wheel plus the 2 that he already had. So no, Mr. Theory's not leaving. He just, I think they're trying to spread him less thinly.
I thought that was him, he was going back to Louisiana.
I think you were in court when he told the whole story. He's getting married. He's going to be here. The new love lady in his life, who's not new, is here. It could be. We'll see. But no, I said it in a way that sounded like he was. He is leaving this division. I was not told what's happening with him. I was told that Mr. Cladis has now the honor and privilege of having 3 courtrooms. But he got dealt a good hand, 3 good courtrooms. So Mr. Abate, we'll sit tight on Mr. Watson. You've reached out to Mr. Theory?
No, I didn't because.
But at 3 o'clock, Watson, I mean, he's got something at 1:30. Position 3 is a conflict defender case.
I'll do that right.
Okay.
I can come back at 3 if that's when it's coming.
Yeah, I mean, it's gonna be complicated because I got to be on a call at 3, so we're gonna start 3-ish. But let's just see. Really, I just want Mr. Watson to know there's a transition, because what Mr. Theory will say is, I don't know, it's not my case anymore. So maybe what's most productive for Mr. Watson is to bring him out and share with him that development. But if one of his lawyers was at least looped in, that might be safer. So just hold for a few minutes and we'll see. At 1:30, we were supposed to do the Heavenly Mitchell Jackson Deno. We've got Ms. Feely. Is that your case, Miss? It's Ms. Bezos. That's why she's here. I don't see Mr. Mitchell, who has always been in court.
I'll go check.
He's only 2 seconds late, so.
Judge, I'll be back at 3 o'clock. If that's okay.
Yeah, that's fine. And you're welcome to Zoom in, but you can walk in however you want to do it. It may start a couple minutes late because of this thing that popped on my calendar for 3. You have only battle to talk about. Oh, right. Okay. Yeah. Be interesting. Okay, thank you.
Let's really try to be efficient, make sure everyone's here, make sure everyone's been transported. No one said, I'm confused. Do I need to come to vote?
Yeah. All right, so we need to get a lawyer. So Mr. Granham's has filed an entry for Pritchett. So Pritchett's covered, just Robinson needs someone. All right.
People that we need, Stokely,
That we need
see.
Stokely, which is like a vehicular homicide, Chambers. How many cases does he have?
Chambers.
Oh, you just said his name a bunch of times. We'll never get a lawyer for him. What? I won't take that.
3 cases. Well, he only needs 2 assignments. Remember Ryan Schwartz is on one of the cases.
Oh.
Remember him being on one of the calls?
So he has retained counsel on one, but that guy won't take the other 2? I wonder if we got Mr. Hiles to talk to him about that one case to say, look, we could resolve all 3 this way. If that guy wouldn't just say, all right, I'll take pleas, and you don't have to do work on the other 2. Oh, I didn't remember that.
That's not too bad.
No. Stokely is going to be hard to do, but no, let's just I'll just tell Mr. Watson, and that way he doesn't need to stick around. Can we just bring Mr. Watson to the door? Hey, Mr. Watson, I'm Judge McBurney. How you doing? I'm all right. Mr. Watson, we were going to have a conversation with you and your lawyer and the prosecutor today about where we are in moving your case along. The state has provided discovery to your lawyer, Mr. Tertiary, and I was going to get an update from him about whether he was missing anything. He didn't file any motions, so we needed to figure out what was next. But I learned earlier this week that Mr. Tertiary has been reassigned, and there is a different defense attorney from his office who will be taking over your representation, a gentleman with the last name of Cladis. He's not here yet. He starts on Monday. He needs to meet you, talk to you about your case before he can have a meaningful conversation with me about what still needs to be done. The way I'm looking at the docket, it seems like your case is ready for trial. But I need to know that from the lawyer who's going to be representing you. So what I'm going to do is have Mr. Cladis meet with you. And after he's had a chance to meet with you and look at the case file, then we can have the conversation that I was hoping we could have today. Mr. Cladis can say, we're good to go, or I'm missing something. There's a police report that says there were pictures taken. I don't have those pictures. We're entitled to them, whatever the facts are. But I need your new lawyer, who is not new as a lawyer, but he'll be new to you. He needs a chance to talk with you and learn a little bit more about your case. Does that make sense? So I know that is a delay, and I apologize for that, but I'm glad that they're getting someone assigned to your case. He'll come see you, and we'll figure out what's next. So I would think in a few weeks, we ought to have you back here to have this discussion about what's next for your case. Can I get you a jury and we can do the trial? Or is there something more your lawyer needs so he can be ready to defend you at that trial? Or maybe it's going to be a plea. I don't know. The state may have an offer to make. pretty serious charges, but sometimes these kinds of charges work out short of trial. Any questions for me about your situation? Okay, good to see you.
But I'll read your discovery as well, since the group now, just another, a third, I think.
It will be cleanest if you don't mind doing that. I have learned that there were some productive discussions between your management and the public, it's not the public defender's office though. You guys are back to using evidence.com and not Dropbox. That needs to be what happens. Just letting you know.
It requires fine jump drives.
Why is evidence? I'm just curious. Why is evidence.com not good? Because apparently, here's what I heard. County invested in that. County, not your office, but like countywide. This is what we're going to do. Training, money, spend, evidence.com. And then all of a sudden, your office started using Dropbox.
I don't know the backstory. I know for the problem with at least murders or the major cases is there's so much to see. You have to individually upload each file, and we have sometimes thousands.
Sure.
So with Dropbox, you can just drop it in to the entire folder, and it will download up. You don't have to do one thing.
So if you have a phone extraction and it's 500 pictures, someone has to put each picture into evidence.com?
Not for a phone extraction. Typically, a phone extraction would be, well, actually, you're right, because if there is a folder typically that has just photographs, you have to click each box.
Yep.
And wait for it to upload.
Okay.
The public defender's office, at least the ones I've been working with, we walk through this, what some people are under the impression is you have to have a Dropbox account to open the link.
Right.
And you don't.
Okay. So there may be a workaround.
Yeah.
All right. I'm not getting in the middle of it. All I know is that someone was going to go to jail in one courtroom because the words were, we don't do evidence.com. We're supposed to do evidence.com, et cetera, or our office won't let us click a Dropbox link. And then you get these judges saying, this is a ridiculous fight to have. So maybe it'll work differently in the rare air of major case.
No, it wasn't me. For one.
It wasn't. It wasn't. So how are we doing finding Mr. Mitchell for the first substantive proceeding since I've had his case?
Miss Feely passed me when I was in the hallway speaking to my client. She was on the phone. So I think that was him that she was speaking with. So I can go check if you would like.
Please do. In the meantime, who is Investigator Lamb? You are. Okay, you're with the DA's office. What case is this part of? Sherry Grant? Ah, okay. Is this the phone that is the property of the other potential suspect, or is this Ms. Grant's phone?
No, it's the other suspect.
And is it a phone that has been cracked, or this would allow your office to try to crack it?
Correct.
The latter?
Yes.
Okay. Sherry Grant is your case, Mr. Abate? Ms. Beza?
Yeah, it's my case, Your Honor.
Whew, that was a quick triple handoff. Why was Mr. Moore not originally indicted? I mean, I'm reading the affidavit and someone says he did it and you want to get in his phone. Why is he not indicted?
I'm not sure, Your Honor. There's been a little bit of disconnect between the DA's office and the police department, so we're trying to square that away right now.
Okay. So there's not an actual search warrant. There's just the affidavit. David. It's not in there. Okay, I'll hold on to this, but I need, the thing you really want me to sign is that other thing. I'll be right here.
I'm with Asia right now, so we'll have.
We can't start till we get Mr. Mitchell here anyway. Okay. Why would he have not? So what's the word from Ms. Feely?
She has indicated that Mr. Mitchell has told her that he is en route to the courthouse, Judge.
Did he have notice? Like, was this news to him to be here, or you don't know?
I know we worked very hard to make contact with him this week, Judge.
Huh, okay. It's different for him. He has always been here. He's been here more frequently than his lawyers, given the transition of attorneys he's had. Do you have the witness or witnesses you need? Is it one witness for the Jackson Deno?
It's two, responding officer and detectives.
Because there are two statements?
Yes, one on scene and one at the precinct.
Okay.
The first one is 8 minutes, the second one's 30, so they're not.
Okay. And you don't need to play the whole statements. You can admit them, but I just need to know what were the circumstances in which they were obtained.
Yeah.
And this is,
Very short.
pardon me?
The testimony is short.
Great. But you've got both officers here, and right now you're not even sure you'd use them, but you want to be able to, should that make sense. So that's why we're doing this.
Yes, Your Honor.
Great. Makes sense.
And a part of one statement, I can't use, but
Because
he was detained, and the officer was questioning him, so half of the first statement.
oh, the responding officer.
Yeah. And he
Got
was
it.
first arrested.
There, you believe there reaches a point in their interaction where you would need to stop the tape because, okay.
I do.
Well, I appreciate your candor on that. You did? Okay. Ms. Wood, what's happening with Ms. Gaines?
Judge, I believe I might have a plea today. Is that okay?
It is never not okay.
I'm gonna step out and sign her up.
Great. Mr. Thomas, you able to stick around for the plea?
Yes, Your Honor, I'm at your disposal.
I'll take that as an enthusiastic yes on a Friday afternoon.
Absolutely, Your Honor.
Excellent. Well, it does not sound like the Jackson Deno hearing will be long. If it happens, we're going to give Mr. Mitchell a few more minutes to make it here, and go from there.
Can I show you something, Judge?
Uh-huh.
Now they're sharing information.
So, and it hasn't been, it was not a uniform issue, but there were some who were told you may not use Dropbox because if it's a big file, we, PD's office, have to pay for a Dropbox account. I don't know how I know what Dropbox does. If you're sending me a Word file, free. If you're sending me a giant file, a 30-minute video confession, apparently one or both of us, at least the thinking was the recipient needs a premium Dropbox account. County's already paid lots of good money for evidence.com. Why should more money be spent to get premium Dropbox accounts? And so a directive was entered, don't accept Dropbox stuff. So it's not you to begin with, but it was, we want to get our evidence through evidence.com. It's what we were trained on. It's what's been paid for. But that perspective wasn't informed with the labor that's involved, relatively speaking, getting things into evidence.com versus into Dropbox. But well, and the folks who are pretty serious about making information flow, adapt.
Interesting.
Yep.
Y'all will receive an email from me as well. I'm going to, someone's going to replace me on Mr. Thomas's case to make it easier.
Really?
Yeah.
Just to make that clean break?
Yes. I don't want to work with Mr. Weintraub.
Well, I had one less thing I need to rule on, but not replacing you because you are being replaced on all your cases. Okay. All right. There's been a lot of like convery. What's next? Oh. All right. So I'll stay here then. Take care. Exactly. I'm gonna throw my mouse at him. No way. So are there any of the things at 3 that we can do now? Nope, not that one. The Kalish one will take 1 second. Interesting to see who shows up for Salmaron. Beard will be quick, I suspect.
Beard is gonna ask to,
More time.
yeah, August would be perfect.
Hope. And then battle. Okay.
Battles. They have a conflict between them.
The guy always has conflicts. It needs to work out. It sounds like there's a reasonable offer, but meaning Pines thinks it's reasonable, but his client not.
He has to massage.
Yeah.
Here, guys.
Okay.
So, the officer was retired, so he did.
Okay. Well, if you see hold your officer's hand for a second, but then please have Ms. Feely come back in and we just need to figure out what we're going to do. I don't want to wait forever for Mr. Mitchell.
Is it okay to put just the one case concurrent, or do you need both
Not sure what you,
on the sentence for?
the guy this morning, Jackson?
Mhm.
Yeah.
Okay, because they only have one. He didn't take a plea on the Mitigation.
Okay. Yeah. So it'd just be Carol or Troop. No, Kawita. I thought Kawita was the one. Kawita, he has to have taken a plea on because that's what they said he had a sentence for.
I didn't just.
Kawita, Carroll cases, Carroll County has not been put.
Yeah. So just the Kawita one.
Right.
Well, and Troop, if there was a Troop one, no one seemed to.
He listed the Carroll County cases, but since they haven't been a plea.
If they haven't been a plea, it's just concurrent because we don't decide that. Carol decides whether they'll be concurrent with us.
Okay, so we'll do concurrent with County.
Yeah. All right, Ms. Feely, tell me what's happening with Mr. Mitchell.
Yes, Your Honor. I
He's,
apologize.
like I said, he's usually always here. And then Ms. Wood shared, he was kind of scarce this week.
So he says that he was having issues with his phone and he mixed up the times like apparently everybody this afternoon did, but he is en route. Again, I apologize. I know that's not like a legal excuse, but
What is en route? Does he live in Texas or does he live on 10th Street?
he lives in the metro area, but he didn't give me an exact.
Like Coweta is the metro area by some definitions. Oh,
I guess that's true. I can see if I can get more visibility. I told him he needed to make every
legal effort to get here. So what we'll do is take Ms. Wood's plea. And if Mr. Mitchell's not here after that, then we'll need to reset this. But I know it was a bit of an effort for the state because at least one of the officers is retired. And I guess what's frustrating about this is that this is done in some ways just to protect, it's not even the defense motion.
We're not challenging the voluntariness or admissibility of the statement, but I understand that.
Well, then why don't you do this? Why don't you see if we'll still do the plea first, because it should be a quick plea. But you should see if Mr. Mitchell is comfortable waiving his presence until he can be here, given that you are not challenging the voluntariness of the statements, with the caveat that Ms. Beza shared with me is that the state is acknowledging partway through that first statement, it becomes involuntary, or at least it's not something that the state would try to get in. And with that stipulation, I mean, frankly, we could almost I don't know if we want to stipulate that the statements were voluntary because you had a chance to review them. You've had a chance to review them. You could tender the videos, which would, if the videos show if the detective read rights to the defense. I don't know the setting for the second one. I understand the setting for the first is officer right there on the scene, and it doesn't sound like he Mirandized him. So some stuff comes in and some doesn't. Then we don't need the hearing. I'll review the pertinent portion of the two videos. And if I agree, I can enter an order that has that magic language that it wasn't under duress or promise of benefit, et cetera. And we short circuit it. So why don't you two talk, and then if Mr. Mitchell can talk while he's traveling, if he agrees with your analysis, he can turn around and the officers can go. And really the record would be the admission of the two videos. Okay, thanks. And be clear, if you're not if neither side is comfortable with that, don't do it. That just seems like an efficient way to take care of it, given this kind of unique posture that the defense agrees with you. But I think it's wise to have an order entered that says the magic words about the two statements.
This is speaking about again, the second is this is not a video that's talking. This one I told him, and I'll tell you what it ends. Everything is spontaneous except for it's very clear. This is spontaneous, like I didn't do this, I didn't do this. And at this point, what happened? You said you walked you out. At this point,
Investigator Lamb, you've worked everywhere.
That's I think it's.
Why are you here now?
I was here before, I came back.
Just couldn't stay away? All right, well, welcome back. You don't hear that from a lot of people. All right, do you swear or affirm that the contents of your affidavit are true and correct to the best of your belief and knowledge?
Is there some stuff that would need to be redacted? I think they probably agree
when
with
he
that.
talks about his yeah, I think everything.
All right, here's your stuff. You just need to sign that last page that's turned sideways, and good luck cracking the phone.
Thank you.
Mhm. Because I keep signing those indictments from this morning. We do. Iron Chef, it was called. Iron Chef. I loved that. The original one where it was in Japanese and then they were translating it. Because that's where they would have really weird ingredients. They say, and the mystery ingredient is like squid eyeballs, make a dessert. They would do that. Iron Chef. Soon we will have no one here. So Tamara, where'd you guys go for lunch? Jersey Mike's, that's it? Yeah. On Broad Street?
We didn't know like where to go. And that's the first place we saw.
Well, good to know. You jump whatever you see first. So how was your cold sub?
It was pretty good. I didn't know they didn't toast this.
Yeah, Jersey Mike's is one of my kids likes that, but it's cold. needless to say, there are better options on Broad Street than Jersey Mike's, but you guys apparently weren't being adventurous. Did you enjoy meeting the other interns?
But I think kind of got lost there. They were filming like a pilot of a show.
Yeah, there are all these film trucks around there. So are you an extra now?
We wanted to be, but no.
No? Oh, well. And were the other interns from this building or from the Russell building?
Only one of them. I only went with one, and they're here, and the intern was the chief.
State Court, Judge Edline. Got it. Well, good. So these 3 pleas this morning will actually only close one case, but we're nibbling away at the others. And if we could get Chambers, then that would take care of it. Well, I don't want one of his, 3 charges. The one where he basically just drove the car fast and ran. Can you give me Tyrell Chambers' case number that has the attorney on it? Is that easy to find? Yeah.
20 SC 176981.
Okay. I'm going to see if Mr. Hiles would be willing to reach out to that lawyer and say, I don't know if Hiles wants to work all 3 out, but if he does, it's a great way to do it.
So how many is left in that division now?
In the gang unit?
Yes.
That's a great question. Ms. Beza, how many gang prosecutors do you have?
I think it's about 5.
5, even with Convery and Parrish leaving?
Well, they haven't left yet.
Oh, Parrish is gone.
Parrish is gone, but Parrish is gone.
So you're counting her?
Yeah.
Okay. Well, I mean, physically she's present, I guess. Yeah.
This morning.
Yeah. So would they have Hiles and Bridges? I don't. Yeah. Maybe you.
No, I let DV.
You're good with the DV?
Yep.
Okay.
Definitely care about the DV.
We yet to see Bridges in action on that.
That we have Mr. Hiles. That's how it is.
Yes.
Don't upset that.
No, we don't want
Good job on the complicated one. No.
makes it really easy for us.
Yeah. So what we'll do, Ms. Beza, assuming Ms. Feely agrees with it, is we'll get on the record in the Mitchell matter. She'll waive her client's presence. You'll tender the 2 videos. We'll get the necessary stipulations from both sides, and then I'll indicate that I'll review them and enter a ruling, which I'll do, if that works for you. Do we need to say in Jackson's other cases, not the big gang one, not concurrent with Coweta case, but concurrent with the other Fulton case? Or we don't need to say concurrent with the Fulton cases because they're all being sentenced at the same time?
I was always taught that if you don't say concurrent, you assume it's concurrent.
Okay, I do too. I would think you'd have to say, I don't want this sentence to start till the next one, until the previous one is done. So I'm not saying we need to change it. Just wanted to make sure you had consciously thought through that. Okay, but that's a good answer. So Ms. Wood, we will get started in just a second. I want to make sure I understand what's happening with Mr. Mitchell, because that may be real quick. Ms. Feely, did you get a chance to talk with him?
Yes, and I think we are, he's okay with the current strategy of us being able to pretty much not have to necessarily.
Yeah, I was gonna say.
Oh, he's here.
Yes.
Mr. Mitchell, where were you coming from?
West side of Atlanta.
Oh, okay. So you weren't coming from like Conyers
No, sir.
to get here. Okay. Well, why don't we get on the record for Mr. Mitchell's case? I'll say what I think I need to say, and then the lawyers can plug in. Ms. Rivers, are you ready?
Yes, Judge, I'm ready.
Okay. This is case 18 SC 161851, State versus Heavenly Mitchell. It's on the calendar today for a Jackson v. Deno hearing concerning the voluntariness of two statements Mr. Mitchell gave, one to the responding officer and one later to the lead detective in his case. Mr. Mitchell is now here. He's represented by Ms. Feely, who is here. So both are in court with me. Ms. Beza represents the state. This is a hearing that actually was called for by the state because the defense doesn't have concerns about the voluntariness of what I'll call 3/4 of Mr. Mitchell's statements. No concern about the statement given to the detective in terms of voluntariness. And apparently about halfway through or some portion into the statement that Mr. Mitchell gave to the responding officer, it shifts to a custodial interview, and Mr. Mitchell was not advised of his Miranda rights. And so the state is conceding that nothing said by Mr. Mitchell after that in response to questioning from the responding officer ought to come in. Given that stipulation from the state and the defense's perspective that we weren't challenging these statements coming in to begin with, we're going to have a stipulated Jackson versus Deno hearing. As I understand it, the state is going to tender both statements. There are video, audio recordings of both statements, both meaning the one initially to the responding officer and the one later to the investigating detective. I will accept those in as evidence. I will review them and then enter an order that specifies that I find, assuming I do, I suspect I will, that the first portion of Mr. Mitchell's statement to the responding officer is voluntary and thus otherwise admissible. And the entirety of Mr. Mitchell's statement to the lead detective is admissible because he was properly Mirandized, et cetera. Now, those are not my findings yet, but given that Ms. Feely is not challenging any of that, I suspect that I will observe when I watch these recordings that things played out as Ms. Beza has described and as Ms. Feely has acknowledged is the case. I'll enter an order, and if I find something different from what the two sides have agreed is the situation, I'll give them a chance to say, wait a minute, Judge, you need to reconsider because. Ms. Beza, does that work for the state?
Yes, Your Honor. And the state also has courtesy copies of transcripts, and I can tell you the exact point where I believe on scene, the conversation with the defendant became custodial.
Okay, that will be helpful. Ms. Feely, anything else on behalf of Mr. Mitchell?
No, Your Honor.
You're comfortable managing this hearing this way?
Yes, and I don't see that there was a written motion. I think this was just like orally moved by Mr. Thomas, is that right?
No, there's a written motion, like the reverse Jackson Deno, I don't remember what I called it. And that was e-filed. And just for the record, the state will be tendering two exhibits. Number one is the body camera of Officer Taylor Proof, about 8 minutes long. And number two, it's the audio recording of Detective Dunham's interview at headquarters. It's about 30 minutes long.
Got it. Ms. Feely, Mr. Mitchell has moved around a little bit in the courtroom. I want to make sure. Oh, okay, that's all. It's fine that you moved. I just want to make sure you didn't need to. Normally, you'd be sitting right there with Ms. Feely. We're not trying to keep you out of the mix, but we were actually about to take a plea, and then you showed up, and we can get you and these detective and officer out of here. So I wanted to do that expediently. So the state is tendering Exhibit 1 and 2. Body cam, and then recording of interview with the detective. Any objection to those being admitted for the purposes of this hearing?
No, Your Honor.
And then you've got a transcript, which I will not accept as the certified copy, but it's just a good way to keep track. And you'll be able to say at minute or line 7 on page 4, that's where we, the state, think the line should be drawn.
I'll put a star by it, Your Honor.
I appreciate the star. And we'll call that Exhibit 3.
Then Exhibit 4 will be Detective Dunham's.
You've got transcripts of both?
Yes, sir.
Okay, wow. It's
Ms. Beza, turn your microphone on, please.
That better?
Yes, thank you.
Were you able to, Ms. Beza gave a little dialogue about what she's tendering. Were you able to make that out, or should she repeat that, Ms. Rivers?
I didn't get that. I just didn't want to keep going much longer.
Okay, thank you. I think that's it. Ms. Feely, anything else on behalf of Mr. Mitchell?
Not as it relates to this motion, Your Honor.
Okay, where are we in terms of you being in a position to be ready to try Mr. Mitchell's case if it's going to be a trial?
I think this one is one that could, again, be potential if I knew to kind of zero in on it. I do need Mr. Mitchell to come meet with me in the office, but otherwise I think this one is one that could be ready.
For June 29th?
Yes, Your Honor.
Okay, if we limit it to just a couple of cases, this could be one of those cases. Okay, and is this one, Ms. Beza, where we need witnesses from out of town or not?
No, Your Honor.
Okay, so you could be ready for June 29th.
Yes.
Excuse me. Great. All right. Mr. Mitchell, please connect with Ms. Feely so she can have that meeting with you. I know you've met with a bunch of lawyers over the many years your case has been pending. We're not letting another lawyer in on your case. It's Ms. Feely till the case is resolved. Trial, plea, dismissal, whatever it's going to be. So I need the two of you to connect in person and not just on the phone.
Yes, sir.
Did you change phones? Because they had a little trouble tracking you down this week.
No, sir, it just pretty much phone dead.
All right, keep it charged.
I will, sir.
All right, sounds good. Ms. Beza, anything else for the state?
No, Your Honor. Is there just a copy machine where I can make, Your Honor, copies of the transcripts?
The copy machine is Ms. Nelson.
Oh, may I approach?
You may. Ms. Feely, anything else on behalf of Mr. Mitchell?
No, I'm going to step outside to speak with him with the court's permission.
Yep, you're good to go. Let's turn to the plea. And Ms. Beza, you've got the files 1 and 2?
I do, Your Honor. May I approach?
You may. Thanks so much. All right, and when Ms. Nelson comes back out, just interact with her. You're free to go. If you don't have anything else, you don't need to ask.
Thank you.
Once I get 3 and 4. All right, let us turn to, where's that calendar? Position 4. Your microphone is on, mine is on, we're set. This is case 21 SC 179392, State versus Simone Gaines. Mr. Thomas, you ready?
Yes, sir.
Great. Then let's do this. Ms. Gaines, in just a moment, Mr. Thomas is going to put you under oath. When you're under oath, you got to make sure all your answers to his questions and mine are truthful and complete. And I would ask you to let Ms. Wood or me know if you've got any questions at any time because you can't hear or someone says something that is confusing or nonsensical or who knows what. If you've hit a point where you're not following what's going on, you need to let Ms. Wood or me know. Will you do that?
Yes, Your Honor.
Then we're ready to go. Mr. Thomas?
All right, thank you, Your Honor. Ms. Gaines, please raise your right hand. Do you swear or affirm that the testimony you shall give in this matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you may lower your right hand. State your true, correct, and legal name.
Simone Monet Gaines.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you normally take that you have not been given today?
No, sir.
How old are you and how far have you gone in school?
23 years of age and the 11th grade.
Are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you're being charged with the following offenses: aggravated assault with a deadly weapon, aggravated battery, and possession of a firearm during the commission of a felony?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, sir.
Have you had enough time to speak with your lawyer, Ms. Wood, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, sir.
Do you need more time to discuss this case with your lawyer?
No, sir.
Are you satisfied with her services?
Yes.
Ms. Wood, do you waive formal reading of the indictment?
So waived.
And do you waive any and all defects in the indictment?
So waived for purposes of this hearing.
Ms. Gaines, have you been arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants that are related to these charges?
We do not.
Has your attorney advised you of the minimum and maximum sentence for each charge you are pleading to today?
Yes, sir.
For charge 1 of aggravated assault with a deadly weapon, the minimum is 1 year, the maximum is 20 years. For charge 2 aggravated battery, the minimum is 1 year, the maximum is 20 years. And for possession of a firearm during the commission of a felony, the maximum is 5 years to run consecutive to any other sentence you may receive. Do you understand that this is a negotiated plea, which means that the state will recommend to the court a sentence of, for count 1, 5 years probation, for count 2, 5 years probation to run concurrent with count 1, and for count 3, 5 years suspended, 5 years probation suspended consecutive to count 1.
Yes, sir.
But the court does not have to accept the recommendation. The court can sentence you to the maximum on each charge. It can run those sentences consecutively or one after the other.
Do you understand that?
Yes, sir.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on entering a guilty plea today?
Yes, sir.
And do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
And do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, sir.
You understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes, sir.
Do you understand that by pleading guilty to a felony, if you use, receive, or possess or transport a firearm or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, sir.
And do you understand that there may be other adverse or unfavorable consequences as a result of a guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, or your ability to obtain employment.
Yes, sir.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes, sir.
Have you ever pled guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No, sir.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No, sir.
Has your lawyer explained the First Offender Act to you?
Yes, sir.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked and you could be adjudicated guilty and you could be resentenced to up to the maximum sentence for each charge in the indictment?
Yes, sir.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a guilty plea?
Yes, sir.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to counsel appointed or to court appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
How do you plead in the charges and indictment number 21 SC 179392?
Yes, sir. Oh, guilty. Sorry.
Okay. Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, sir.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that you may have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Your Honor, this case would have went to trial. The state would have proven beyond a reasonable doubt that on June 24th, 2021, in the vicinity of 2515 Piedmont Road Northeast, at the residence of Jaelia Clay, that's spelled Jaelia, the defendant's former girlfriend and the victim were hanging out. The defendant arrived at Ms. Clay's home and began beating on the door, demanding to be let inside. A verbal altercation transpired between Ms. Clay and the defendant. Ms. Clay allowed the defendant into her apartment. The victim heard the altercation and locked himself in the bathroom. The defendant then demanded to know who was inside the room and threatened to shoot her gun if she didn't find out. Ms. Clay did not tell the defendant who was inside the bedroom. The defendant then fired a gun through the door, striking the victim in the abdomen. The defendant then fled the scene. Officers responded. Officers did respond to the scene. The victim was taken to the hospital. And based on the statements on the scene, arrest warrants were drawn for Ms. Simone Gaines. So, Your Honor, Ms. Gaines does not have any felony history, which is why she is able to take the Felony First Offender Act today. I actually just talked to the victim in this case about 2 hours ago. He does not want her to go to jail or have any jail time. She did spend 70 days in county jail before she made bond. The victim mainly just wanted the stay away order, which shouldn't be a problem because the defendant and victim actually do not know each other. And the victim is actually working on leaving the area on business. So that shouldn't be a problem. Your Honor, we're also asking for a mental health evaluation and then follow-on treatment based on whatever that evaluation has. And then obviously no weapons. And we are asking the defendant to complete the family violence intervention program. And and then that's all we're asking for, Your Honor. So based on that, we believe this is a fair resolution to this case. And this is a resolution that the victim is 100% on board with.
Talk to me about your understanding of Mr. Thomas's injury. If he was shot in the abdomen, that says to me that had Ms. Gaines fired her gun an inch this way or an inch that way, Mr. Thomas is dead. Was he actually hit? Was it a graze wound to the side or?
So Your Honor, he was hit and he was transported to the hospital. This shooting being a little over a year ago, he actually has no lasting effects of the shooting at all. In fact, he's actually trying out to go to the NBA right now. So he's very athletic, and this incident has not affected his earning potential, or hasn't affected him at all, which is why he's on board with just making sure that Ms. Gaines gets treatment and Ms. Gaines stays away from him.
Got it. And Ms. Clay is not seeking any stay away. I appreciate she's not the direct victim. She's clearly a collateral victim. Ms. Gaines in Ms. Clay's household fires a gun and potentially kills a visitor of Ms. Clay's.
Yes, Your Honor. Our office has talked with Ms. Clay, and she has not expressed any desire to have any interaction with this case whatsoever.
Okay. Thank you. Ms. Tucson, I'm glad you rejoined us. Do you have any information that suggests Ms. Gaines is not eligible for first offender treatment?
She's not on probation.
Okay.
She doesn't have any priors.
No priors. Okay. Thank you. All right. Ms. Wood.
If I could have one moment with Ms. Gaines, Judge.
Okay.
Thank you, Judge. Ms. Gaines is 23 years old. She is a resident of Gwinnett County. Her mother is here present in court to support her. She has an 11th grade education. I have encouraged her, and I'm sure the court will agree that it will be a good idea for her to get her GED while she's on probation. She is gainfully employed with a swimming pool company. And as Mr. Thomas stated, she did serve 70 days in jail. So we would ask for credit from June 25th, 2021 until September 2nd, 2021. Otherwise, Judge, Ms. Gaines has been very involved in her case from day one. She's indicated to me she has absolutely no issue staying away from the victims or the incident location, as they all seem to have moved on from this incident. We would ask to be sentenced under the First Offender Act, and Ms. Gaines also is asking the court to consider waiving her probation fees. Otherwise, we just ask that you accept the state's recommendation.
All right. Did you and Ms. Gaines fill out a plea form?
Yes. Would you like that, Judge?
I would. Ms. Gaines, if you'd show your client her signature, is that your signature? I think it's on page 4, the second to last page.
Yes, Your Honor.
And you had a chance to discuss that plea form with Ms. Wood?
Yes, yes, Your Honor.
She answered whatever questions you had?
Yes, sir.
And Ms. Wood, you signed the following page?
Yes, Judge.
Got it. Yes, I would like that, please. Thank you.
May I approve?
You may. Mr. Thomas, there's no restitution. First, are you related to Lance Thomas?
I am not, Your Honor.
Okay, figure we get that on the record. Is there any restitution that Mr. Thomas is seeking for the medical treatment he received?
No, Your Honor.
The NBA is taking care of that?
Hopefully.
Okay, Ms. Gaines, what's the name of the company you work for?
Latham Pool, sir.
And what do you do for them?
It's a pool liner that you just create. So I really just kind of sew this like plastic material together, like 40 to 50 hours a week.
So you're in sort of a factory setting?
Yeah, like a warehouse.
So I might order a pool liner, you get the specifications and you're helping sew the liner.
Yes, sir.
How'd you get the job?
Just kind of went online, looked around, not too far from my home, so I wouldn't be too far out, and applied for it and got the position.
And your home is where?
Gwinnett County, Boggs Road.
Okay. How long have you worked there?
I want to say about 7 to 8 months.
You said 40 to 50 hours. What days of the week do you work?
Monday through Saturday.
Why 6 days a week?
It's just the demand of the job.
Okay. If you worked 5 days a week, would they still keep you? You just earn less money, or do they?
Yeah, it's like less money. So Saturday is like, it's overtime, but if they require it, then I have to show up.
Okay. But if you were not available on Saturday and Sunday, would they fire you, or they would just understand because there's high demand, you're a valuable worker Monday through Friday?
I think they will understand. It's a pretty good, reasonable company. If I had any things from you guys that I needed to be done, then they will understand that.
Okay. All right. Mr. Thomas, not the prosecutor, but Lance Thomas, who was in Ms. Clay's house. Is that someone you had met before?
I think I went to high school with him, but I don't have any like relationships with him. I don't know much about him.
You and Ms. Clay and he hadn't been hanging out as
Never.
a threesome,
Never.
meaning just going out, friends, whatever.
Yeah, no.
Okay. Ms. Clay was your girlfriend for a while.
Yeah.
Okay.
Yes, sir.
Did Mr. Thomas have any role in the two of you breaking up that
I
you're
don't
aware
think-
of?
No.
Okay. And what was the purpose of going to Ms. Clay's place on June 24th of last year?
So I had recently moved out, I want to say within like a week and a half. It was
You
both
had
of
been
our-
living there.
That was both of our home. We got the home together. It was under her name because of my credit issues. So once we broke up, I decided to move out. We were still like interacting, like being friends. My job was not too far. I worked at a truck driving company, so I was still kind of over there, and we were like working with each other. So the night before, I had stayed over, and then I had just got there to pick up my bag, and I want to say maybe like an hour later, I came back over because we were like having a disagreement during like text messages about our relationship. I came over and we were when I came over to the home, I realized someone was in there, and like nobody has never like been inside of our home before. So once I asked to basically come in, she kind of like regretted it, and we started to like physically fight each other. I pulled away, went into the bathroom, which is connected to the bedroom. I realized it was a guy in there. I could hear him talking. I had my weapon on me, and as we're like fighting, I pulled away and it fired through the door, and that's how he kind of got like hit, I guess, wherever he got hit in his body. I kind of got nervous, but I didn't realize he was hit. We checked on him before I left. He opened the door. We checked his body. I left because I got nervous. Then I got a call from my mother saying that he was actually hit by the gun wound. I called her, asked, was he okay? I was still frustrated. And then that's pretty much, it went from there. I turned myself in, and this is how it's been going.
What did you have the gun for?
I had recently got the gun because it was just me and her in that home.
So it was for safety.
It was just for safety because of like both of our jobs and stuff like that. We were just two women. I had recently went to go move with my mother after we broken up, and I had like siblings over, like nieces and nephews coming from out of state. I didn't have a room at the time. I brought my gun with me just to keep it from being in that home, and this whole incident happened.
First offender is something you're eligible for. It doesn't come up a lot in shooting cases, but your situation is a little different now that I've learned a bit more about it. If you are sentenced as a first offender, it means that it's not a conviction. So even though you have a sentence, and if I follow this recommendation, You'll be under sentence technically for 10 years, 5 of which are probation, which will involve supervision for some, if not all of that period. And then it's suspended. But during none of that time are you a convicted felon. So if you decide to go back to school or you're looking for another job and there's a question, have you ever been convicted of a felony? The honest and legally correct answer is no, you have not.
Okay.
If you successfully complete your sentence without your first offender status being taken, then or revoked, then this can be removed from your record and it remains not a conviction. So it's primarily a benefit. You're young, you got a lot of your life ahead of you, and having a felony, in particular, a felony where you shot someone hanging over your head, can make life more difficult depending on what your vision is. If you want to go back to school or move up through a company. That's the benefit. The risk of first offender is that if while you are under this sentence, something else comes up, you get violent with another person, you get arrested, you use a gun, you can't have a gun while you're under sentence, you get caught with a gun, anything like that. Not only do you have to deal with that new charge, but you will come back before me. And if the state demonstrated that you in fact did the things that you're accused of doing, I'd have to see what the situation is, but I could take away your first offender status because you've already pled guilty. I could sentence you up to the maximum in your case, which I think here is going to be 25 years. I think counts 1 and 2 merge for purposes of sentencing, but we'll get to that in a minute. I just need you to understand that if you're worried about how you're going to handle situations in the future because you've got a new significant other and it doesn't end well, and you're going to have a gun, you're going to do something unwise, not only would you have that new case, but I could sentence you up to 25 years in this case in jail without a trial. You'd have a hearing about whether you had violated your probation. But if I decided to take away your first offender status, I have to resentence you as a felon, and I would have a pretty big range to work with. So it can end very poorly. And for some folks, it's just not worth the risk because they know the lifestyle they're going to lead when they leave this courtroom. For other folks, it's a great opportunity to have made a mistake. And this was a pretty bad mistake, but try to move on from it. You know better than anyone, better than Ms. Wood, better than your mom, whether it makes sense for you to be a first offender. Do you feel like you understand the benefit of first offender?
I do.
Do you understand the risk of first offender?
Yes, sir.
Do you want to be sentenced as a first offender?
Yes, sir.
Okay. Well, Ms. Gaines, I find there is a factual basis for your plea. You've added a little context to it. You did shoot Mr. Thomas. It may have been sort of a byproduct of a tussle you were having with Ms. Clay. Frankly, you could have shot Ms. Clay intentionally or not because you had a loaded gun and you were tussling with someone. And that was a bad choice.
Yes, sir.
And we're fortunate that whatever injury Mr. Thomas sustained didn't kill him, didn't incapacitate him, and he's apparently trying out for the NBA. So it went about as well as it could. I also find that your plea is knowing and voluntary. Knowing means you've understood all the things we've been talking about, anything Ms. Wood said or Mr. Thomas, the prosecutor, said, or anything I said. Do you have any questions about any of the stuff we've been talking about?
No, sir. No, Your Honor.
Okay. Voluntary means no one's forcing you to take this plea, but you've decided this is the way you want to move forward. Is that true?
Yes, Your Honor.
Okay, then I'm going to accept your plea. I am not going to follow the negotiation exactly because I think this is more serious. And that's not to suggest Mr. Thomas was saying it's not serious, but I don't find that 70 days in jail is enough for what happened here, because a question of inches and you're looking at life. If Mr. Thomas had died, I suspect if you had shot, Mr. Thomas didn't die, but you blew his eye out, that the state would not be recommending what they're recommending. And so you got lucky. And Mr. Thomas, the victim, was able to more or less walk away from the situation. But you had a loaded gun in a volatile situation that you shouldn't have. I'm not going to send you to prison, but I am going to impose as a special condition of your probation that you're going to spend 10 weekends in jail. So you'll be checking yourself into the jail on a Friday, and you're going to have 10 consecutive weekends where you're checking back in just to have time to reflect on how you need to never have that situation come up again. And by that, I don't mean that you get into a dispute with someone you care about. That's going to happen. I hope you have a new significant other. You may already, but the way you work through that needs to never involve you pulling a gun out, because it can end, as we know, real tragically. And it didn't here, and you're lucky about that. I will sentence you on, I think count 1 merges into count 2. Count 2, I'm sentencing you to 5 years probation. Count 3 has to run consecutive to count 2, and that has to be 5 years. I'm suspending that. So the sentence that your lawyer negotiated for you is about the same. It's a 10-year sentence, 5 on probation, 5 suspended. I am adding a rather punitive special condition of probation because I think it's appropriate given how serious this is. And that is, it's a special condition of your probation. It doesn't start this weekend because I appreciate it's Friday, but starting next weekend, you'll need to report to the county jail on Friday. Whenever you report, you get out 2 days later. So if you report at noon, you're out at noon on Sunday. If you report at 5 p.m., you're out at 5 p.m. on Sunday. That's why I asked about your job. You've had it for a while, and it may not be the job you want to have forever, but it's working for now. But what you told me is you don't think you'll lose your job because you're going to not work for a few Saturdays in a row. If that changes, you should let Ms. Wood know, and we can figure out another way to get those 20 days of custody. That's 10 weekends. But generally, if it doesn't interfere with that Monday to Friday, it's not fun, it's not convenient. That's the point. It will also be a special condition of your probation that you complete a family violence intervention program. That's not one class, it's a series of classes that will help you cope with stress in personal relationships in a way differently than this one ended. It will also be a special condition of your probation that you get your GED. You don't have to do that right away. You got 5 years, but don't wait till 4 years and 9 months because you got to do some studying to get that GED. But that will help you move to your next job. You'll, as an additional special condition, you need to submit to a mental health evaluation. I don't pretend to know that you've got any issues other than you were angry that day. And it may be that a mental health professional says Ms. Gaines is doing fine. But if that mental health professional says you should get some counseling, maybe you're depressed and ought to take medication X or Y, that course of treatment that the mental health professional recommends will become part of your probation. And finally, no contact, direct or indirect, with Mr. Thomas. That sounds like he's a stranger to you, but anyone can find pretty much anyone these days. Don't send him texts or post something about him or to him. He needs to go his way and you go your way. I think I covered all of the conditions I wanted to have, and those included the ones Mr. Thomas asked for. Mr. Thomas, anything else in connection with Ms. Gaines's case?
No, Your Honor. I think you've already made it clear that she is to have no weapons, so I think you covered everything.
Sure. Plus, that's the law. First offender probationers, it is a felony for a first offender probationer to have a gun because you're under sentence. So if you get pulled over and there's a gun in the car, it may start out as just, oh, you had a concealed weapon, but that'll blow up into a felony. And that is the kind of thing that will cause me to take away your first offender status. You and guns are done. It didn't work out well, and you'll need to do something different. Bye, Tamara. I forgot to mention Probation Options Management Act. I'm sentencing you under that act. And what that means is that while you're on probation, Ms. Gaines, if you have a small or a technical violation, you and probation can sort that out. That's not going to cost you first offender status. But if it is more significant, you're arrested again, you don't comply with the special condition of weekends in jail, something like that, then we will need to get together, you, me, and your lawyer and the prosecutor to figure out what we're going to do. Last thing I have is that I've got your indictment on my screen here. I'm going to electronically sign it on your behalf with your permission, indicating your guilty plea. Is that all right?
Yes, Your Honor.
Ms. Wood, can I sign for you?
Yes, Your Honor.
Mr. Thomas, may I sign for you?
Yes, Your Honor.
Great. That's how we'll handle it. Ms. Wood, anything from the defense?
Let me just check, Judge. Do you have
Okay.
any questions?
I'll turn myself into the county jail here.
Yeah, so Judge, just so we're all clear, it is Rice Street, correct?
Yes, that's my understanding, but let's ask our professional in the room, Deputy Gordon. Ms. Gaines, female, she doesn't go down to Union City. She would check in at Rice Street, and whether they transport her to Union City or not, it's the sheriff's decision. But for folks who are just coming in for weekends, my experience is they go to Rice Street. Yeah.
It'd be a Friday to Sunday.
Yeah, so if you
Okay.
turn in on a Friday, it's 2 days later. If you go in on Saturday, it's 2 days
Okay.
after that.
Okay.
Yeah. So if your schedule is such that you're checking in Saturday morning, you'll get out Monday morning. They're going to do that 48-hour clock, and then you get out.
Okay.
All right.
Do you
Yes,
have
Your
any other
Honor.
questions?
My ankle monitors.
Okay.
Yeah.
Judge, she did have a question about her ankle monitor that she's on. It's my understanding that once all the paperwork is in, that just gets sent over to the ankle monitoring company. Does that sound correct?
It does. I don't know the
Okay.
mechanics, but your ankle monitor was a condition of your bond. And once I sign your sentence, you're not on bond anymore. And so it needs to come off. Whether you go to pretrial services or A&A to get it taken off, you should try to do that next week, because next weekend you'll be checking in the jail and they're going to get the heebies if you got ankle monitor on. They may take it off and you want someone else to have taken it off, so it's not on you when you report for that first weekend.
Okay. Yes, sir.
And last thing, just word of advice. If something comes up and you don't think you can make it on a particular weekend, let Ms. Wood know so she can let me know. Because there are folks, probation will be monitoring it, and they will let me know if you missed a weekend. If you missed a weekend because you're in the hospital and you were so out of it you couldn't reach out to anyone, that's okay. But if you missed because there was a funeral or something, you knew that in advance, and you need to get the okay in advance. I don't share this with you to say, hey, you should try to negotiate out of those. It's 10 weekends and it's going to happen. You might as well get them taken care of up front. But if something arises in your life where you believe it's significant enough that you ought to have a weekend moved to the end of the line, talk to Ms. Wood and she can give you her thoughts. No, going to the Braves game isn't the kind of thing that will qualify. But a funeral is the kind of thing where I would say, if asked, sure, that particular weekend will move to the end, because your sentence is going to say it's every weekend starting the weekend of June 10th. That's next weekend. Ms. Nelson has asked, do you believe because she's going to put the dates in there. Do you believe that you're going to be a Friday report or a Saturday report?
Friday report.
Okay, so June
Work at
10th.
like 2:30, so I can be able to probably
Okay.
make it over in the afternoon.
Jail's open 24/7, so you'll check in when you check in. So it will be Friday, June 10th, a week from today will be your first report. And it'll be 10 weekends in a row, unless something comes up. And it's always better to get approval before than to have missed it and say, oh, you know what, my nephew, he had a graduation and I went to that. That will go less well. All right.
Yes, Your Honor.
Okay. Last thing, I know I keep saying that. The sentence that I just gave you is a little different, and it is a little different in a way that makes it more severe. You have the right at this juncture to say, I'd rather go to trial and see what happens with a jury hearing that I shot someone. So you and Ms. Wood should talk for just a second, and then Ms. Wood or you need to let me know that you actually do want to go forward with the plea, even though it didn't work out quite. It's pretty close, but not quite what you negotiated. Okay.
Thank you, Judge.
Ms. Wood, what have you decided? You and your client.
She would like to accept it, Judge.
Okay, that's how we'll handle it, Ms. Gaines. Keep Ms. Wood's phone number, reach out to her if something comes up. I wish you the best going forward, and hope you are able to stay out of scenarios like these.
Yes, Your Honor, thank you.
You're welcome.
All right, there you go. That is yours to keep. Oh, does she need reporting instructions for probation?
She does. Ms. Tucson, you want to get with,
Yes, Judge, I will send over the reporting instructions to Ms. Wood in her email. It looks like because she's going to be in Gwinnett, I put on the reporting instructions to 410 West Oak Street, Lawrenceville, Georgia, 30046 on June 20th at 9 a.m. But I will email a copy over to Ms. Wood.
fantastic.
Thank you.
No problem.
All right.
All right.
And I'll send that to you once I get it, okay?
Okay, thank you.
All
so
right, you're
much.
free to go.
Thank you.
You're welcome.
All right, thank you, Your Honor. May I be excused?
Yes, sir. Thanks for hanging in there. Have a great weekend.
All right, you too.
Let us handle at least one of our pretrial conferences now, because I have to step away at 3 for a few minutes, even though this was scheduled at 3. My bad, not Ms. Nelson's. She scheduled first. But I'm seeing on the call that we've got Mr. Secret. Hello, Mr. Secret.
Hello, Judge. How are you?
I'm well. How are you?
I'm doing very well, thank you.
How goes firm life?
It's a new life, and I love it, quite frankly.
Good. So we have you on here for Mr. Beard. I don't know that Ms. Love has joined us yet, but we're awash with prosecutors, and so the state is amply represented. Mr. Beard, very old case, but new to you. And you had said, Judge, at best, I'll be ready for that last date, which is coming up, the June 29th. But you also signaled that that might be too aggressive. What is the update on your ability to be ready? And also whether you and the state have engaged in any discussions about non-trial resolutions?
We have had discussions about non-trial resolutions. I am not in a position to say whether or not we will or have made any progress. They have made a somewhat unique kind of way to resolve it. My client has something else in mind. I sent that response to Ms. Love last week. I have not heard back from her. It is my intention to have further discussions with them and Ms. Willis, if I need to, about it in the coming days. It is an aggressive date for me on the 29th that, as I mentioned to you, Judge, I jokingly said that was my birthday, but I meant that to say that I had a planned leave of absence for that period of time that I have shared with Ms. Nielsen that I have filed in federal court already. And it's basically intention, and I told her in being in all candor, was to take my grandchildren for the first time to see their family in Nebraska and Vegas. Since the pandemic, I haven't seen any of them. So it was my intention to leave on the 20th and return on the 8th of July.
Okay. We have a trial calendar the week of July 11th, and we also have one the last week in July. If we teed this up for that last week in July, it spills over into early August. Is that something you could be ready for if you haven't managed to resolve the case with Ms. Love and or Ms. Willis?
I would make myself be ready for that. As I mentioned to Ms. Nielsen, August would certainly be much better for me than July. But if there were a trial calendar available in that month, but if July, the last of August is the date that the court would set, we would endeavor to be ready if we don't have a resolution.
Okay. Well, you're sort of getting what you want, because the jury would be picked on the 28th of July if Beard went forward, and then it would spill over into August. So you'd get some August out of that July 28th date.
Yes, sir.
All right. So I'm going to say that is the likely next spot for Mr. Beard. My recollection of the case is that Mr. Beard and the person who is deceased shot each other a bunch of times. And so this does seem like a case that ought to be resolvable. But I will leave that to you, Ms. Love and Ms. Willis. And if it's not, then the state can expend the resources to try it again on July 28th.
All right, Judge. Thank you very much for your consideration.
You're welcome. I want to have one more conversation, two more before I have to step away for a minute. Who was on? I thought I saw Mr. Kelleher, you're on. I don't think Mr. Zimmerman's going to join us. Maybe he has a delegate on his behalf.
I have heard nothing from him. I can reach out to him if you'd like me to find out.
No, you don't need to, because it's a simple one. The way the state has always presented it, your client and Mr. Zimmerman's client are not going to trial. It would be Pritchett and Robinson, but Mr. Robinson's lawyer just quit. And so the next step we have to take is to get Mr. Robinson a lawyer. There was an entry of appearance, but it's the new C3 lawyer for Mr. Pritchett. That's who should be on the case. That's Mr. Granham's. So Mr. Pritchett's case structurally is in the right place. We'll see where Mr. Pritchett is. But Mr. Robinson needs a lawyer. He's coming to court next week to let me know whether he's going to retain someone or we get someone appointed, and we'll cross that bridge. But for you, Mr. Keller here and Mr. Zimmerman, there's really nothing to do other than continue to wait based on the immunity orders that have been entered. And we'll see when we can tee up the trial of Robinson and Pritchett. Okay.
Okay. Who's taking this over?
Mr. Hiles, he'll wave his hand. You'll see him front and center.
Back again.
Yep, he's back. So he knows the case very well. He does not have a learning curve for this gang case.
Yep, we were actively engaged on this from the preliminary hearing. So, all right, great. Just, I guess I am then at the discretion of the court as far as when that gets set.
Yep. Well, we're at the discretion of finding another lawyer. So we'll work on that and you'll get notice. Okay.
Sounds good.
Great.
Thanks. Good to see you, Judge.
Same. Last one. I see
Your
this.
Honor.
Yeah.
I'm sorry. I don't know if you see Tracy Dorfman, but I'm here on behalf of Noah Pines. He's out of town. So I'm on the Michael Battle case whenever you're ready for that.
Okay. I was not going to take that one up next.
I just know if you didn't know who I was.
Got it. Thank you. Ms. Hilton, I wanted to talk about Mr. Rooks because that's the one that I see, if we're not trying Mr. Connor, as being likely ready to go on June 29th. It's a date you had okayed long ago, but Mr. Korn's not here. Was someone able to speak on his behalf?
I can reach out, Judge.
Okay. Ms. Hilton, just before I step away, any updates from the state? Still ready to go on the 29th?
We're still ready. We might have one witness issue, but we'll figure it out, but we'll be ready.
Figure it out as in it's not your lead detective.
It's not my lead detective. It's a very important witness, but we'll figure out if I need to fly her from where she's going to be.
All right, great. Okay, we'll see if we can get Mr. Korn on the call.
I know he said he was on vacation the last time and he was going to email us a status. I'm not sure if he's being able to communicate that.
Okay, we don't have an update from him, but he is not available. And he did let Ms. Nelson know he had leave. So he had said before the 29th was far enough out, and the way he was going to handle the brain tissue samples is whether he calls Dr. Sperry or not, he had given up on finding an expert.
Okay. I didn't realize that. Okay.
Yeah, that's what I had heard, is they'd given up on the expert. So he was ready to go. We'll confirm that because I don't want you getting all geared up if he has backtracked from that. But I'll make a note to have him share with you and Ms. Nelson and me what the situation is. All right, I got to go. I will be back. I'm sorry. But I'll make it as quick as I can. So the rest of you can just relax.
And will that, am I excused, Your Honor?
You are, yes. That's why I was trying to, ones I knew I could take care of real quickly.
Thank you, Your Honor.
All right, I'll be back.
Happy birthday.
Thank you.
Happy birthday.
Thanks.
Yeah. I don't think so.
I'm going to the vending machine. Would you like anything?
I think I'm good. Is that the one that's on like the first one? I went down there and looked.
Was there nothing in there? I haven't been down there in a while.
Yeah, there was some stuff in there.
I'm gonna check it out.
Can it be here for a whole?
No, that's why I'm like, why?
Because I don't have anything. Do you?
No, where?
So we're done on, we did Connor, we're done with.
That one's done. That one's done. There's literally that. Oh wait, we might be done. Hold on.
Why didn't he just? So Rachel's been pestering me about having a drink. Interesting.
That's not us. Oh my gosh. Yeah, no, we're done. Why are we here? I like thought there was more on here. Just put this energy out into the universe. And it's not happening.
Yeah.
But if he comes back out here, we're all gone.
I know, right?
Oh my God, Emily mentioned.
Okay, he shakes his head. Yes.
I mean, I just because this is just gonna keep happening. Like, he was ready right now.
Oh, yeah,
and it's just like he claims he's gonna. We did set up an appointment. I'm sure he's not gonna come here for Wednesday. He was like, "Can we do a culture show?" I was like, "No, we are sitting here right now." No, he's not coming, but we did it.
Yeah, good. No,
it's in my calendar. I will be at the office. He thinks she's A, not coming, or B, just gonna all of a sudden say to him. If neither one of those things happen, then we'll try. If
Yeah.
he actually like we know him to be in this.
Yeah.
I think he will testify pretty well if we can get him to. I guess I won't be able to prep him if he won't come down.
Yeah, but it's good. Yeah.
Because I was doing a thousand and one things.
Well, I do want to kind of hear what happens, but okay, we already talked about Brooks, right?
Right.
It's not going right. So there's no-
I'll be shocked if it does.
Because I would love it if somebody besides me tried. I mean, I think it is going to be me, but it would be really nice to see a trial before. Although this is way too many things going on, so that can't go.
Yeah, that one's definitely not going because that one's two people are missing attorneys on this one.
Do we already talk about that?
We did. You talked about this one? Right, so then it's down to just these three.
It doesn't mean.
Yeah, that's what it is. That's what it is.
Yes.
We're getting somebody.
Your birthday was yesterday, so Lauren's going to Charlie.
Well, thank you.
Oh, she's cupcakes.
Yeah.
Oh, really?
Oh, that's okay.
Changes.
Yeah.
Like. So that much.
No, I don't remember. Oh my God, yeah.
So those are my things. Yes. Happened this morning at the fair.
No way.
She's one of the
Jerry is a woman. Right?
Yeah.
Oh my God. I'm so interested.
Farmington. It seems very
For sure.
Yeah, so huge. Lots of. And the judges want to about
Yes.
Trying to pin her video.
She's next door and she and she like stuff just uncomfortable. I would like seeing that today, like a couple of things. Is she, how much should I do this? She's like, she just did. Oh, yes.
He's the one. And the kids. We're gonna have to give it to him. He's the most guilty person that ever heard.
Oh, I hate those cases. Yeah.
He actually was very guilty. He was like, "Oh, I'm really terrible." So how much time did we give up for a trial? I mean, he put it on, but he didn't do any of it because they brought him right out. Right. Do you have any questions? Do you have anything to say? I asked you to please. Oh, yeah, like, yes, that did happen. Yes. I looked up Jackson v. Down and found cases done, so I figured out how it was. Yes, so. He was not, he was on vacation. He's another teacher. Yes, so why is he, good question, yeah, so this case that he has is really old. Okay. Before I came to this office, they were looking for that time, and his position at the time was like a backup attorney. And so I don't remember the logistics of how, but that case, however it made its way here, he had to follow it here. So he's technically assigned to, he's a supervisor, but he's currently still filling in. He's in Detroit. Yeah, so that's why he's in. Okay. This is a very serious case. It's a murder. And so it's like always moving parts to it. So yeah, that's why he called it. Okay. Yeah, that's a good question though. We don't really, sometimes that's really the only people where this is not, sometimes it's the supervisors. Yeah, but not. Yeah. So like Maryland. Yeah, because yeah, it's over exams. Okay. I think that's it though. Good questions. Thank you. They tend to. They just speak to. Yeah, so they have different divisions, so. Okay. Siri, what's the name of your division? Crimes Against Children. Okay, so Travis, he's crimes against. His domestic violence. Right, I can never keep it straight, so there's all these different divisions, so that's why, so like if, one of them has questions, we can talk to them. Yeah, say like, they like sometimes make announcements for each other, so yes, they all are the same office, it's just different divisions. But it seems they can speak for each other a lot easier. Yeah. Different areas, is that just because they have a lot of different states, or that they essentially have a lot of thing? It's, I mean, it's kind of, the state is the state. Okay. So, like Judge Russell used to say that, like the state is the state, whoever, someone from the state has to be there. Okay. Yeah, that's why we like also don't really do the whole, like, we can't really file leave and say we're not available to try a case on a day. Yeah. Someone has to try it, so. Okay, so it might not be the person that's been doing it the whole time. It just has to be someone from the state. Okay. That makes sense. Thank you, Sarah. Because I didn't know that there was a location, so that's why I was scrambling to find out what his announcement was. Yeah. So yeah. What is this in traffic? Oh, I think these for Salman. Yes, Salman. Are they brothers? No, fathers. What is your next week? Nothing. Okay. If you want to come join us, yes. At least 3 different 4 days. And I know I have some, well, I have in office interviews with on scheduling, so yeah. But you're welcome to like submit it. Yeah, we have 2 days next week. Okay. He has something like research for us to do. That's the only thing, so there's like a timeline for that really. So I imagine just like from what I did this before, and if I'm not in court, I'll put on the other stuff. Okay. But yeah, you're welcome to join us.
Sorry, I'm back. Other Zoom is over. Okay, let me get back to our list. We already did Mr. Connor, we did Mr. Rooks, we did Pritchett and Robinson. That gets us to the Salmarones. Who do we have there? Siri Patel, your case? All right, and then Mr. Theory, I know it will not be your case maybe as of Monday, but right now is your case. And then Ms. Teal, you're handling this matter?
Yes, Judge.
Great to see you again. How goes everything with our other case?
Everything's looking good, Judge. Looks like we're going to be entering a plea on it.
Okay, well, you just let Ms. Nelson know when and we'll handle that. But we're here with the Salmarones, and I think we have an interpreter on as well, Ms. Mendez Porter. I don't know, I don't have the interpreter feature yet, which allows 2 people to go into a separate channel and Ms. Mendez Porter could hear what I'm saying, or anyone else, and she could be speaking to Felix Salmeron. But this really wasn't a client necessarily being plugged in situation. So why don't we talk a little bit, and if there's something, Ms. Teal, you represent Felix or Ruben?
Felix, Judge.
Okay, if there's something you want to have translated, we could pause and have Ms. Mendez Porter do that. I wanted to understand where we were in terms of this being trial ready for June 29th. And it may be moot on your side, Ms. Teal, if the state wants to try the defendants together, because Mr. Theory will not have this case as of next week, and his replacement in this division, I'm expecting not to be ready to go on this. But Mr. Theory, why don't you tell me the plan from the conflict defender side?
Well, Your Honor, I believe that the new attorney will begin on Monday in your court. I don't want to say that name unless I'm mistaken. I believe there will be a Ms. Rivera, and hopefully she can try to get up to speed on this as quickly as possible.
So it better be Mr. Cladis, because that's who we were told it would be, and that's who I reached out to.
Mr. Cladis. That's why I shouldn't have said the name.
There you go. So you'll be handing over all your cases or just some?
All of my cases, Your Honor. I will no longer be in your courtroom.
I'm sorry, we didn't get to do much at all. You took some great pleas, but no trials.
Yes, I would have liked to have stayed in the courtroom, but supervisors had other ideas.
So where are you ending up?
Judge Adams and Carnesville.
All right, good luck with that. So I will get together with Mr. Cladis next week to help him prioritize. Ms. Teal, my focus with Mr. Cladis is going to be older in custody cases. So I think for now, we will not look to the Salmeron case as one that will go to trial the week of June 29th, because I'm going to want Mr. Cladis working on other things. Is there anything, Ms. Teal, you are lacking in this case? Since I've got everyone here, what I would want to avoid is when we do put this on the next trial calendar, it appears on for one side to say, wait, I never got discovery.
Judge, I just want to confirm, my office was advised by the state that there is no video footage, and I want to confirm that that's accurate. I'm seeing some indications that there was video taken based on reports. Is there no video footage available from the state?
No, Ms. Teal, and actually it was served on Mr. Mann. Let me pull up the discovery certificate.
Meaning Mr. Mann received the video?
Yes, Mr. Mann did receive an evidence.com link that did have video in it. That's really easy. I can send it to you, Ms. Teal. But I did file a certificate of service, and I can forward you the emails that I sent him regarding the various videos that were in there.
That's fine. I don't need those. If you'll just send me the video, that's all I need. I'm going to be taking over the case, as well as another one Mr. Mann was handling. He's having some health issues.
Okay, yeah.
And then one last thing from the state, there's a witness list contained in the discovery, but it's blank.
Okay, I will make sure you get the actual witness list then.
Okay.
So I owe you those two things.
Confirm that you have my email address.
Yes. Do you mind announcing it, or do you want to send it to me in the chat?
That's fine. It's Kendall, KENDALL.
Okay.
At HinesLaw.
Okay.
.org.
Okay.
HINES.
That's right, Ron.
HinesLaw.org. Excellent. So Ms. Teal, you will receive the evidence.com link from Ms. Patel. That will have all the video evidence in it. And then you should have what you need. And we'll work with Mr. Cladis to make sure he's got the same. Mr. Theory, your plan is to just basically deliver a big truckload of McBurney files to Mr. Cladis?
They've already been delivered, Your Honor, and I will go over with him the cases that I had, especially from your April 5th trial calendar that I was on. And so I will be getting with him regarding the Tolbert case and the Reynolds case. And I'd have to have that calendar in front of me as well.
That's all right. I'm gonna be meeting with him, so I appreciate it. I just want to make sure you were delivering to him and not to whatever other attorney's name you mentioned, all the case files.
Well, actually, there was Ms. Bernard, but I will get with him and talk with him about the cases that I'm familiar with to get him up to speed on what I had done that he can't tell from my bad handwriting in the files.
Excellent. All right. I think that's it. Ms. Teal, do you need anything from Ms. Mendez, or can I excuse her?
No, Judge, they can be excused.
Okay. Thank you, Ms. Mendez. Have a great weekend.
Thank you, Your Honor. You too. Thank you, Ms. Teal.
Thank you.
We've talked about Dexter Beard, so we only have two left. We've got Mr. Holt. Mr. Terry, still your case until Monday. Mr. Holt is here. We brought him over. Is that correct? Okay, Mr. Holt is here. He didn't show up for court once and so lost his bond after having been on bond for a long time. What is the plan for today, if any, Mr. Terry?
Well, Your Honor, I would not be trying to have a bond hearing in case it gets denied, and I will talk to Mr. Gladys about filing for a bond reinstatement when the proper time arises, when there's change in circumstances. As far as Mr. Holt's matter, I will try to get Mr. Gladys up to speed for trial. As from my understanding and conversations with ADA Charles, at this point, this case is in the trial posture, as he would not be accepting the 10 years to serve at this point.
Okay. So I know there were some plea negotiations, but right now they are not fruitful.
Correct, Your Honor.
Okay. All right. Anything we should bring Mr. Holt out to hear since he's here? I think we'll do that just to let him know that he is transitioning attorneys and that Mr. Gladys will be here to see him soon. If you don't mind, Deputy Gordon. And then Ms. Dorfman, we're to you. He can be, no, right there is fine. Mr. Holt, how you doing? Good afternoon. Mr. Holt, you are represented by Mr. Terry. Mr. Terry has been reassigned to a different courtroom, and so there's a different conflict defender who's going to be handling your case going forward. His name is Mr. Gladys. Mr. Gladys is going to see you soon. He starts on Monday, and he's going to come visit you to talk about your case. Understand the state's made an offer that you're not particularly interested in. He's also going to talk to you about bond because something happened and you missed court, but it sounds like there's an explanation. Today is not the day we're going to go through that. But your lawyer, Mr. Terry, was aware of that situation. He's handing all that over to Mr. Gladys, who needs to be your spokesperson. Mr. Gladys will come see you. And then if what we need to do next is have a motions hearing about your bond being revoked, we'll certainly do that. I'm not interested in keeping you stuck until trial, although we also need to get you a trial. So we'll do that. But probably the order in which we do it is, well, the first thing that has to happen is Mr. Gladys needs to come meet you. You can let him know what's going on. Then if we need to have a bond hearing, we'll do that. And then ultimately, if your case isn't resolving with a plea, we got to get you a second trial, okay?
I see you while I'm incarcerated. I got a son and I got a fiance.
I understand all that. You also had a court date and you weren't here. And you were out on some pretty serious charges and you've already been found guilty once on those charges. So you are where you need to be until someone presents me with evidence as to why it was okay for you to have skipped court. And that evidence may be out there. Mr. Gladys needs to get it from your fiance or your mom or your uncle or you. and then we can have a discussion about it. But you don't get to just miss court and say, hey, it's not a big deal, Judge. So there may have been a great reason why you missed court, but your lawyer needs to present that to me, and the state needs a chance to say, it's not such a great reason. Okay?
So I'm not going to sign another lawyer.
You do. I know you've had a lot, but this lawyer, I'm going to try to convince to stick around. And your lawyer, Mr. Thayer, it's not like he quit. His boss has said you're working with a couple other judges. He was working with 8 judges, which stretched him a little thinly. So now he's going to work with just a few, and someone who's working with another judge is going to be working with me as well.
So I didn't have no supernatural reason why I did come to court. I changed the address and I didn't get the letter.
Okay.
I said that to my attorney at that time. When I came to court, this court date was the last court that passed. They said that he wasn't my attorney. I left I was checking in with pretrial services. My address that I changed, I gave it to my attorney at that time, but she no longer was my attorney when I came to this court.
Yeah.
But now I'm getting switched again. I'm willing to do house arrest or whatever I have to do. I just need to be out there for my family. And that was my reason.
Okay.
So last time to wait on him, he doesn't know the reason. Only the person that knows why I didn't come to court is me, sir.
Okay.
And I gave it to, I don't even know his name, the white guy at the time.
Okay. Probably Mr. Webb.
Mr. Webb.
Yeah.
I got to court, they said he wasn't my attorney.
Yeah.
And now it's just, that's my excuse, sir. And that's not, if it's not the greatest excuse in the world.
It could be perfectly acceptable. We got to get Mr. Cladis to connect with you, get you back here, and we'll make it happen quickly. Like I said, he starts on Monday, and he and I are going to sit down and say, here are your different cases. He's got a bunch, but there's some we're going to prioritize. I'll make sure he talks to you, not to get ready for trial, but to talk about this bond situation. And it may well be that what he proposes is that you get an ankle monitor and it's house arrest or something. But I may find that based on those conditions and the fact that you've got some stability out there with the fiance and the son, that's okay. But you and I can't just solo have that conversation. All right. I hear your frustration. It's justified. We try not to play musical chairs with lawyers. But I'll tell you that a lawyer is better than no lawyer. Okay. We'll see you soon. Less than a month. All right, our last matter is Mr. Battle, and Ms. Dorfman is here on behalf of Mr. Pines, who had a conflict, and Ms. Patel is here. I think the case is trial ready. I'm playing back what I've heard from the lawyers before. It's trial ready. The hard part is getting Mr. Pines. And in fact, there have been some very productive plea negotiations. And Mr. Pines relayed to me that he thinks there's been a reasonable offer, but of course, he's not the one who needs to accept it. I'll start with the state, just because you're consistent across this, and Ms. Dorfman is subbing right now. Where are we in maybe resolving the case?
I gave Mr. Pines my final offer May 1st, and that's kind of where it stopped. There's one part, the registry part of it, that I'm not budging on, and I think his client has rejected that part of it. So I'm holding the offer open until trial. So at this point, we're ready for trial if need be.
Okay. Ms. Dorfman, what is Mr. Pines' schedule? This is slated to be on the June 29th trial calendar.
And he does have on his leave of absence, Your Honor, he has leave June 27th through June 29th. So he will not be back until the 30th. I don't know, and then he's open. I don't know when your next, I think he's still very hopeful that this will be a plea. I'm familiar with this case, Ms. Patel, and I think her offer is very, very fair. I prosecuted these cases in Gwinnett for 15 years, and I think it's a very fair offer. But again, obviously the client has to agree. So if he doesn't plea, then we are ready for trial.
Okay. Let me look the case up, because I just feel like Mr. Pines' leave keeps changing.
And I've got his most current one in front of me.
Well, you having it is good for you.
Did he send it to Ms. Nelson?
Well, but you know, you file these things, you don't just email someone. So I'm looking to see what we've got in the docket. That wasn't the right number. What's the battle case number? Because the email, the Odyssey number isn't the right one. The thing in Outlook's not the right one.
1635, that's not good.
635 is correct. What's in the, it's 636 in the Outlook thing, but it's all good. All right. Let's see here. Leave of absence. June 27th through June 29th. It's like he saw when I had jury selection. Okay. Well, that'll make it hard to pick a jury on that day. Is this a case, Ms. Patel, where you need to bring witnesses in from far and wide?
No, they're all local.
Okay. Well, gosh, then. All right. I don't want to keep you on, Ms. Dorfman. He's got to leave for June 29th, and that I have to pick the jury then. I get specific days. Judges get specific days for picking juries. We don't invent the days. We have to do them on certain days. So I'll need to see when else Mr. Pines can make it to court.
Do you, okay, you don't want me to give him another date that to be ready, or because I'm.
Well, I'm just looking at all his leaves he's got here. Let me look. 11 through 15. How long do you think the case would last, Ms. Patel?
Evidence would take a day and a half.
Short
Yes,
trial.
It is, yeah.
The prosecutor's conference is what week?
Yes, but I'm not going to that, so I'll be here.
Okay. Well, July 11th, we are picking a jury.
Okay.
So it seems like we could put battle on that. But let me ask, because it's not a mistrials case, July 28th. Even better. I think we'll put it on, well, I reserve the right to put it on both because he's hard to track down. So battle will probably appear on both, but the July 28th date is better because Ms. Charles is on leave and it's not a Ms. Charles case. But this will all be published. None of this is a surprise. These calendars will be published soon. It's early June.
Okay.
And more importantly, Mr. Pines does not have leave for either of those dates.
Okay.
So I've got it there. You do not need to worry about appearing on June 29th.
Okay.
Okay. And Ms. Dorfman, if you would let Mr. Pines know that Mr. Battle will certainly be on the July 28th trial calendar, and that's the day jury is selected. That's what that date is. And he may well be on the July 11th. Neither of those conflicts with his current leave.
Thank you, Your Honor. And
You're very welcome.
If they do agree to the plea, that would be taken care of before the July 28th.
Oh, please. Yeah. If Mr. Battle comes around or the state changes its posture, Ms. Patel knows. She'll reach out to Ms. Nelson saying we've got a plea. Mr. Battle's on bond. We could do that whenever we could get all three people in court. We don't need to jail transport or anything.
Okay. Very good.
All right.
Thank
Thanks.
you. May I have excused?
Yes, ma'am. Thanks for staying late on a Friday.
Thank you. I appreciate it.
All right. So let me just talk briefly with the lawyers who are here and on the call about what the 29th now is looking like. So Connor and Rooks, and this is mostly for you, Ms. Feely, so you can figure out, oh, what is it you want me to get ready for? Connor, Rooks, Mitchell, I think Sherry Grant, is that the conflict defender? I know what the case is. All right, so that would be Mr. Cladis.
I think I have Miss Grant. Yes.
You have Miss Grant?
I believe so. She just doesn't have court. I don't think so. I in here.
Okay.
She's on an upcoming motion calendar.
It is, but I think it's one of these Jackson v. Deno, let's be, but I just signed a search warrant that'll let the state try to get into the phone of the person Ms. Grant says is the shooter, who hasn't been charged. That may be a reason to tap the brakes a little bit.
She's also the client who is pregnant and due this one. So just a heads up.
Okay, but regardless, she's on bond, and Ms. Feely has 2 other cases that are older. And so I'm just trying to manage all that. Nunez is going to be
It's gonna be a head on the schedule, we're gonna get to the next week and work with that.
all right. So that would take care of that. So really, we are down to Connor, Rooks, and Mitchell. We can't do Robinson and Pritchett. And Grant, I would put behind Connor and Mitchell, and I'm assuming Ms. Feely, you would say, could we please just do 2 and not 3 for you to be ready for? Carr, we're stuck because the alleged victim is in federal custody in Florida. And whatever he's told you, Ms. Charles, may make you rethink the case. Okay. We just talked about Salmoron, new lawyer, Beard.
What date did you do here?
July 28th. And that's a perfect case for that. Oh, except that's not your case, Miss Charles. So that's a good week for that. Holt, let's do a bond hearing for him. Okay. And then Nunez. Okay. So we're down to 3. That's such a small number. So Connor, Rooks, and Mitchell. Connor would be first because he's in jail. I don't know that it's the oldest, but he is in jail. And then it would be Rooks, and then it would be Mitchell. I'll take care of the order in Mitchell. That doesn't change the posture of anything. On June 29th. So I'll be bugging all the lawyers on those 3 cases to make sure there are no hiccups. We'll need to hear from Mr. Korn that all systems are still go with Rooks. That's a trial. I had heard rumblings that Connor could still be resolved, but it's first out. So if it's going to be resolved, you'll want to do it just as a courtesy to Mr. Korn and Ms. Hilton.
Absolutely.
Further in advance. And then the fallback would be Mitchell. So folks should get Mitchell ready, but just be coordinating with Ms. Hilton and Mr. Korn. And if they're telling you is going. The only thing I heard, we didn't hear from Mr. Korn, is there's one witness that could be complicated for the state, but Ms. Hilton, as she usually does, said, I'll make it happen. So Connor, Rooks, Mitchell for the 29th, assuming Nunez is a plea soon. All right.
So Mr. Connor's medical issues are not, I know we were talking about it potentially interfering with that trial.
And they could. That's why I'm going to be bugging you guys. If Mr. Connor is on life support on June 15th, then it's not a trial. Another reason to try to work it out.
Yeah.
Department of Corrections may provide better healthcare than we get here. I don't know, but at least then that variable is not our variable anymore. Okay. But that would be a reason we couldn't go forward with Mr. Connor. State is ready. I have heard no reason why the state will be not ready on Connor, Rooks, or Mitchell.
Yes.
And so the only source of not ready would be the public defender's office. It would be Mr. Connor's not well. I don't know what it would be from Mr. Korn, but I'm going to reach out to him. And then with Mr. Mitchell, I didn't hear anything. So Mr. Mitchell would be ready. So one of those would be what we try with the jury that's selected on June 29th. And since we got all the lawyers right here, except for Mr. Korn, the way that plays out, June 29th is a Wednesday. And we pick the jury that day. We do, and then we do trial. We just start with trial. That's right. So we'll do 2 days of trial, and then there's a 3-day weekend because it's the 4th of July. But we would just pick a jury where we know the jurors could be with us into that first week of July a bit. Connor, if it goes, is Is it your case, Ms. Patel?
Yes.
Yeah, how long would the state's presentation be?
2 days.
Okay.
I'm not including like opening, closing. I mean,
No, I understand. So, but it's gonna spill over into that first week of July, just barely, but it will. But that is triable. If we get jurors qualified through the middle of the first week of July, that's long enough,
Yes.
unless there's some huge defense.
I don't expect our case to take long. I'm concerned about the 413. You don't think it'll take that long?
It won't,
Okay.
no.
Okay, but still, if their jurors are good through July 8 or 9, Wednesday or Thursday, that's plenty. Rooks is a little more complicated, and we don't have any lawyers here to tell me how long that'll take. How about Mitchell?
That one is Miss Basa's.
Oh, that's right.
Case.
Okay.
I can text both of them.
No.
Okay.
That's people have given a lot today. So I don't think it would, I think Rooks is the one that would probably take the longest.
Yes, I think that's accurate.
All right. Expect just periodic check-ins, how we're doing with Mr. Connor's health, any updates, and there'll probably just be an email to the lawyers on all 3 cases rather than individualized, just so we know what to expect. And that, I think, is it. That's 26 days from now. Everyone stay healthy.
And on that note, I was just gonna say, the second week of, or the week of July 11th, my husband's having surgery. So if we do go into that week, Miss McCauley will take over for me for Mr. Connor's case.
Oh, okay.
Yeah.
That would be a really long rebuttal case, I guess, given how long you said. But no, it's good to know. And even better to know you've got backup.
Yes, I do. I have backup, but yeah, it's, if anything goes that 2 weeks of July, I will be having someone else cover. for me.
Okay. I hope everything's all right with your husband. Great. Anything else from Ms. Patel? You currently represent the state for these 3 trials. They're good?
Yes.
All right. And Ms. Feely, anything else? All right. So hopefully that'll help you prioritize. I know we're pulling you in lots of directions and new cases come in all the time, but for the 29th, don't worry about Grant. Just Mitchell and Connor.
Okay.
All right. Thank you, everyone. Let's get Mr. Nunez in here soon. And Lefty Hodge is going to be a plea. It's a different date.
Yeah, June 9th.
Yeah. Are you suddenly handling it now? My gosh, you're like the 15th prosecutor on it. Yeah. Pretrial services should show up with cake for everyone. He is, if not the longest serving, the second longest serving pretrial service person.
Really?
Yeah. We get a list every month of the list of shame. One of them is who's been in jail the longest without a trial. And then there's the pretrial service one. And I think there's a guy whose last name is Christmas, there's something funky with his appeal.
Yeah.
He's the longest. But then it's,
Judge Ingram?
I think it's now Richardson.
Okay.
It's bounced. I mean, it's so old. It's like on his 5th judge too.
It's a gang case, right?
I just know it's old.
I just
and it's not mine.
Christmas and gangs.
Yeah. See you guys.
Hi, George.
Bye, Mr. Terry. Have a great wedding. If I don't see you before then.
Thank you. Appreciate it.
All right. Hope it goes through.
Oh, sure. Yeah, she's not getting rid of me, so she'll put up with me. Yes.
Excellent. Well, good luck with that. Thanks for your help while you were with us.